6, Your Honor, is the policy for performance improvement plan from Johns Hopkins All Children's Hospital, effective April 18th, 2016. Produced to us 2 days ago, I believe.
Judge, one, no one's testified about it, so it's not rebuttal. It's just been produced. No one requested it before. So what issue does it go to? This jury's going to decide.
It goes in rebuttal to witness Anderson's testimony about Catherine Beatty's annual performance reviews and that she met and exceeded standards. And we will have a witness to testify in rebuttal.
The witness didn't testify about these policies.
Was Catherine Beatty placed onto a performance improvement plan?
No.
Your Honor, that policy speaks to annual reviews. That is the specific issue in that policy.
What part does it tell me where I should be looking?
Can you pull up 2806, please?
Well, then we're gonna have to put in the deposition explain why there wasn't a referral.
Right.
Judge, what I'm getting from this, they want to imply that we didn't do our annual review. The court is well aware of this changeover. I'm not sure what issue this goes to.
Can you point to me the specific language?
In Roman numeral 1C, it talks about the annual review cycle in the at the end of the third sentence. The court may recall that we took this deposition on Sunday afternoon because we were missing a performance review of Catherine Beatty from October of 2016 all the way until July of 2018. So the hospital did not comply with its own policy to conduct an annual review of this employee. Now they have a story about a transition from one system to another, but the fact is the policy that was in effect at the time required an annual review of the employee.
She wasn't put on a performance improvement plan, Judge.
Well, that was going to be my question. Because this, as I'm reading it, unless I'm reading it wrong, the prerequisite is being on a performance improvement plan. Was she on a performance improvement plan?
That is the negligence. The fact that you have...
Well, Mr. Whitney, she either was or was not.
She was not, and the argument is an employee with this disciplinary history not being on a performance improvement plan is exactly the problem.
2806 is not coming into evidence. What's next?
2808.
It's the same issue, Judge, just later dated. It's now in May 2018.
So this is a policy that was not in effect at the time?
Correct.
It's in effect. The performance review from 2018 is now in evidence. They put it in this morning.
Her stipulation.
And the issue is that we brought this up at the time of Mr. Anderson's testimony that there was this gap in her record. So the next performance review that would cover the period from November to January of Maya's admission is her 2018 review. And this policy governs the review that was done, which overlaps with Maya's admission.
What does this policy say that you're trying to use?
Performance management, job performance evaluation, competency. It all goes to the review of her that's in evidence. It provides context for whether she was meeting and exceeding the standards.
Well, wouldn't the actual performance evaluation speak to that as opposed to what the policy was to do it or not to do it?
It talks about what should be done if performance review, they're not meeting standards. It talks about the 7-step process.
Well, do the performance reviews show that Ms. Beatty was not meeting expectations?
Yes, the 2018 review does.
No,
Beg your pardon.
Her
I would
rating
like-
is something like 2.4 out of 5 in that review, markedly lower than what it was the previous review.
judges, first of all, it's 2018. Secondly,
Well,
the
let's not,
review-
the 2018, I think you were trying to tell me encompasses the time from that October 2016 because of the glitch.
No,
in
what
your
we're
system.
saying is that she didn't get a review in 2017. They did it then, but let's assume that it's relevant.
Well, assume that it is, because I think, given the context here, I think there's a fair implication that the review went from October 2016 to whatever date it was.
Well, I think, Judge, here's her overall review is 2.96 out of 5. She got needs improvement in quality and goals. Everything else is meet expectations, meets, exceeds, meets.
So
I'm not sure how they're saying
2808
this policy.
2808 is a different policy than what I just excluded, which what I excluded was the performance improvement plan. This policy speaks to just the performance evaluation.
Nick?
What's the
It
What's the
speaks
point
to
of it?
it speaks to the performance evaluation, and it speaks to where performance is deficient, what steps the organization needs to take.
So,
And
Judge,
she just confirmed that on a 5-point scale, she was below a 3. That is not meeting expectations. And there's several areas she identified that she needed improvement in. So what did the organization do in accordance with its policy? That's a fair question.
Judge, first of all, this performance review is done, as we've discussed, in July of 2018. She got a 2.96, rounded up, that's a 3. And I think they're not being clear on what is it they want to do, that we didn't do a performance eval? That is their argument that after she got a review in 18, we should have done some more things? That has nothing to do with the time frame we're involving. They're going to say after 2018, because her overall was 2.96, you should have done some more things with capability. It has nothing to do with any of the claims in front of this jury, which is her behavior during the time she's there.
On the timing issue, Mr. Whitney, this policy, it looks like, is it May of 2018?
Right.
Yes,
It looks like there was a previous policy from 2014, but
that's what I attempted to put in a few moments ago.
I thought it was a
That was-
performance improvement plan.
Yes.
Your Honor, this is the policy that would govern the performance evaluation that Ms. Crawls is referencing in 2018. I recognize that it was written in 2018, but this policy governed the look back to November of 2016 when Maya Kowalski was still in the hospital.
Let me understand this, because the last one, the one that I just excluded, had performance improvement plan. The one I'm looking at now talks about performance management. Is it the same policy, just superseded in 2018, or are they two different policies?
They are two different policies, Your Honor.
Are you moving in the performance management policy from 2014?
If I had it, I would, but that was not produced to me. Here's the policies I have, so Your Honor's clear. I have one that's called the Performance Competency Document. My understanding of that document is that deals with qualifications. Then I have two policies called Performance Improvement Plan. One from 2016, one from 2019. I understand the court excluded the Performance Improvement Plan policy from 2016. What I'm left with, out of the four policies they provided to me, is the Performance Management Policy from 2018. If there is a performance management plan that predates this, I don't have it.
Judge, but
Can someone call the hospital and get the policy that was in effect at the time that Ms. Kowalski was there?
I produced them the corrective action policy.
Then let's print it out for me right now.
That's
I'd
a
like-
different issue. That's a red herring. We're about to get to that. The corrective action policy is not governing performance evaluations.
What was the policy in effect at the time Ms. Kowalski was in the hospital governing performance evaluations? What is that? Can someone please print it out or put it up on the screen for me? Is that possible?
That's it right there. Performance, that's improvement plan. He's looking for the performance management. I think they have one from 2015, Judge, can you put that on this, can you just have it?
Do you guys have the performance competency document?
2805-01.
Yes, the performance competency document is not the performance management plan. This has to do with job responsibilities. We didn't feel that this was relevant to what we're doing here. We're not taking issue with an employee's qualifications for the job. That's what that policy speaks to.
I think they just changed the name, Judge, but we'll clarify it. But that's the performance competency document from 2015. Now it's called performance management.
Well, whatever you just put on the screen, how is there a 2017 copyright date with an effective date of 2015? Down at the bottom left, how is that possible?
They may have amended it, Judge.
I think, I don't know this, but remember, during this transition, when they were switching over management, perhaps this is because they're adopting Johns Hopkins policies out of Baltimore rather than using the one at All Children's. But I've asked for every policy.
Wouldn't it say supersedes? I mean, how would you copyright something in 2017 when it was effective in 2015?
I've asked for all these policies. I've given them everything I've had. I've double checked.
Okay. I want you to call right now
Okay.
and ask, what's the name of this performance?
The one I have from 2018, Your Honor, is called performance management.
Okay, the performance management policy that was in effect when Ms. Kowalski was there. Have them email it to you, and we'll print it out right now.
And I don't know if the court was more observant than plaintiffs, but at the top right of this policy, it does say supersedes a June 2nd, 2014
What's
policy.
the number? Can you put it back up, please, just so I can see the number?
Which exhibit?
2808.
Can you put up 28?
It's posted.
In the top right corner, you'll see it superseded the previous policy.
No, he's saying it supersedes.
Ooh, there's even a policy number.
Let me look for it. Hold on.
Okay.
Mr. Shapiro, looks like
Where do you see the policy?
I don't see.
HR 082. Performance management. Okay, while Mr. Shapiro is making that telephone call, what's next?
We received this morning the corrective action policy from All Children's Hospital. It's not yet marked. Do we have available to show the court? I have an extra copy here for Your Honor.
Corrective action. What does this one go to?
It goes to the corrective action notice that was issued to Catherine Beatty in November of 2016 during my Kowalski's admission. And the progressive disciplinary process we discussed this morning. May I approach?
But
Yes.
there was no progressive
Okay.
disciplinary action. There was one incident, they did the first step, and there's no indication they did anything further or action.
Except for the actual discipline reference to prior incidents. I mean, the document itself referenced 2 prior incidents. If I remember correctly. Am I misremembering?
Absolutely correct. 2 previous occasions she'd been counseled.
Somebody posted. I just got it.
Yeah, if you could post it, that's correct.
Okay. Just so the transcript is clear, is there a identification of exhibit number that I'm looking at right now?
We don't have one yet, Your Honor, because we received it.
Madam Clerk, put the next number for ID on this one, just so we can control what we're talking about and the transcript will be clear.
Yeah, and Judge, I think the previous things that were mentioned were verbal in that corrective action. I don't think that this,
Well, isn't a verbal reprimand still part of progressive discipline?
I,
Every place I've ever seen, verbal reprimands are part of progressive discipline.
so that's the first step. And then the second is written corrective action, which is what they did. They did the written.
No, that was just verbal. They never got to written down.
Okay, so 2809 for ID is what is called All Children's Health System Corrective Action. And so what year is this document we're looking at right now, 2809?
It's before, I don't remember the date, but it's the one, it's like 2009 maybe even. It's
Is this the policy that was in effect?
that's my understanding.
Okay, so we agree that this is governing at the time that Ms. Kowalski was
That's
at the
my
hospital. Now, help me understand, Mr. Whitney, how this policy is being used in your case.
As the court has noted, Exhibit 2278, 036, and 037, it describes.
I'm on 2809 right now.
I understand. The corrective action notice that was issued to Ms. Beatty describes 2 previous occasions of her being counseled. And under this policy, even verbal counseling must be documented by the supervisor. And the record of that verbal counseling should, and on page 2, B1, the record of the employee should reflect all pertinent information and the date of the meeting as well as the scheduled follow-up date.
Judge, what count does this go to?
Malpractice and
just
negligent
asking.
management.
So what is the specific objection?
Well, Judge, I'm not sure how they're going to use this. If we look at the actual corrective action notice that was taken with Ms. Beatty, she received a verbal, they have different levels, and this was a verbal corrective action that they took. So is there argument they should have done more? How is this relevant to anything?
Court's going to receive 2809.
Okay.
I'm going to overrule the relevance objection. What's next?
Next, Your Honor, is 2160-028.
What am I looking at now?
You're looking at billing records for Mike Wilson.
Are these from the hospital?
Yes, Your Honor.
How's that rebuttal?
Didn't they get put in through in the defense's case?
Yeah, how's that about?
No, they didn't put them in, Your Honor. They raised the issue that we had not put them appropriately in our case in chief, and I mentioned at the time we'd be moving into evidence. So here they are.
We object. This isn't rebuttal. If they failed to move in something evidence in their case in chief, and I was precluded from questioning my witness about certain records, so we object to this. They failed to move this in their case. This is not rebuttal.
I'm not sure how.
What do you mean you were precluded?
Yeah.
What
Because
are you saying that I precluded you from doing?
I had to question the witness based on the EPI records. They never moved these into evidence. I don't know.
Didn't you show the witness the billing record to verify that the Aetna version of the bill was the exact same thing?
Right, to refresh his recollection, but these are not in evidence, so I don't know what this would be rebuttal
And
to.
there was some sort of agreement with Mr. Altenburn about DV motions and this count and issues.
That was purely about the lien. There was a discussion, if you may recall, and it's slightly vague in my mind, counsel, Your Honor, but there was an agreement that they didn't have to prove the lien. And then Mr. Anderson came in and took my recollection and said, no, that's not what we're going to, we took away the agreement, if if you may recall, there was this whole kerfuffle about, I guess we don't have an agreement when Mr. Altenberg was here. So, but it was strictly, do we have to put in the fact that there's a lien? That was the only discussion about stipulation.
I have a different memory of that.
The whole issue seems to me, if there's already some evidence, I don't see the harm in actually putting in the bills. I had already addressed any sort of DV motion previously, so let's just put it in. So the court received, is it 028 through what?
Through 041, Your Honor.
And everything is appropriately redacted as far as any sort of...
We reviewed it over lunch. We didn't see any compromising information.
Court receives 2160 pages 28 through 41, you said?
Yes, Your Honor.
Okay, what's next?
2161 -59 to 128.
What is this?
This is more hospital records regarding billing for Mike Walski.
Again, this would seem to be things that they forgot to move into their case in chief. It's not rebuttal.
Can you give me the next couple pages?
So we object to it.
Sorry, Your Honor, we'll go page by page.
Wait, so go back for a second. On the top middle, it says something about DCF Sarasota County.
But perhaps the hospital could explain why that is located there.
Well, no questions were asked about this, Judge, because it wasn't in evidence.
Why does it say August 2, 2021?
Most of the records, this is a guess. Most of the records from the hospital have a printed date on them. That's my guess.
Yeah, Judge, we don't have a witness here to authenticate this, what this is about. This isn't rebuttal to anything. Again,
We're not sure.
I don't even know what this is. I've never seen this before.
Yeah. I think at this point, Mr. Whitney, this one has too many questions and we need to move on to something else.
All right. And 2, 1.
So I am not receiving that document.
Understood.
That was just to be clear, 2161.
2161 pages 59 to 128.
And then 2162-90 to 177.
The same issue, Judge.
Yeah, DCF Sarasota.
Understood.
I don't know what this is either.
We'll withdraw.
Okay, what's next? Mr. Shapiro, did you ever hear back from?
Yeah, the preliminary answer I did hear back was it's in an archive system that they don't have access to, but they're trying to see if there's some way to get access to.
Well, I surely hope we don't have to leave the evidence open over the weekend to address this one issue.
I understand.
What's next, Mr. Whitney, knowing that the jury is waiting?
Yes, Your Honor. I think with that proviso that we're waiting on that policy, we also have listed here 2279, but I think
What?
we'll 2279. But I think we would only move to admit those if there's a punitives case. So at this time, I don't think the court needs to do anything.
So with respect to witnesses, just so we make sure, some of this has to be redacted, like the letter and things of that sort. Are any of these being used with witnesses, Mr. Whitney?
I'm sorry?
Are any of these being used with witnesses that we have to worry about?
Which?
Any of your exhibits that you just...
Yes. We will be using exhibits for witnesses.
Okay, I don't know if you're trying to deliberately misunderstand me, I'm just not being clear, which is certainly possible. But 2277, 253, which has to be redacted, is that being used with a witness? Because if so, I want to address something with the court. If not, it can wait.
Oh, yes, that will be used with Mr. Kowalski.
Okay.
sorry.
So, Judge, we addressed 2277253. I'm not revisiting that, except I wanted to just, except I am. I just wanted to ask the court to increase the redaction.
Can I see where we are?
Yeah, 2277253. Can somebody pull it up?
We're on the A version at this time?
Yes, Your Honor.
I would request that the first paragraph there stop at Beata Kowalski and does not include, I wanted to assure you had a copy of the court's order on shelter review. I don't think that should be in there.
I know, I think it specifically needs to be in there because it goes to the question notice.
Okay.
Okay, so at this point in time, I will receive, what was that number again?
The one we just, the letter?
2277-253A.
Court receives 2277-253A. Mr. Anderson.
In light of the, I guess, rejection of an agreement or that we didn't come to agreement, I'm not here to argue that. I just want to make sure on the record that we are not going to have DV arguments about lack of damages on the fraudulent billing. I have here, and it's at 2052-001, one of the Dunning letters and lien updates that we would seek to admit through Mr. Kowalski, so long, but that's only if we're facing arguments that didn't prove damages. What I understand we're doing is...
I remember, without a doubt, the lien issue was part of the agreement with Mr. Altenberg.
Yeah.
So that portion I don't have any problem with because the lien issue was specifically included. It was the never regions of the agreement.
All I cared about was the lien. I just wanted to make sure...
The lien issue is off the table for the jury and for us. That's a post... If we need to get there, it's a post-judgment issue.
Oh, I see. I see. So they just...
Agreed.
See,
So, all right. I just need to do something in the verdict form and take care of it, make sure they don't ask a question, and we'll be fine.
don't worry about the verdict form. Mr. Elligott's got it well in control with Mr. Altenberg. Don't concern yourself with the verdict form, Mr.
Yes,
Anderson.
sir. I'll stay away from it. We have one other thing. Dan has been able to find an interpreter for Ukrainian. I just spent 45 minutes with Elena Kushner, and I am concerned over her English. I think I can pull it off, but it would be a lot better if I took Mr. Kowalski first and then waited for an interpreter to get here from Elena.
Tick tock, tick tock. Let's go. I mean, you can call her a little bit later on, but
We have no objection to them going with Jack next.
Yeah, if it gets down to it, I'll just call
we're
it
done. We're done. Can I bring in the jury?
Yes, Your Honor.
Jurors entering.
Okay, please be seated, everybody. Members of the jury want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and received no information. Is that all correct? Correct. You did not read any media accounts or see any media accounts of this case. Is that correct? Correct. And no one approached you. Is that correct? Correct. Okay, we're still in the rebuttal case. Plaintiffs, call your next witness.
Kowalski.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
State your name, please.
Jack Kowalski.
Mr. Kowalski, and during the defense case, there appeared to be an issue over Sally Smith and your interaction. At the time that you first met, who turns out to be Sally Smith, will you please tell the jury what you were doing?
Objection, Your Honor. Again, this is not rebuttal.
Yes, it is.
Overruled. You can answer that question.
There was some testimony that we heard from Dr. Sally Smith, and
So we again move to strike with a comment on another witness's testimony.
Just give us
okay,
what you were doing.
okay, I'm
Answer
sorry.
the question that was asked.
No problem. I was in the room with Maya. She was getting a bowel clean out. She was having a lot of feces everywhere. The nurse that was in the room, she was extremely helpful, handing me washcloths, towels, linen for the bed. During that time, the nurse walked out, and then in walked a woman with a lab coat on.
Your
And
Honor,
just
respectfully, this is covered in.
You can finish it, and then let me hear the next question.
What were
I'm
you?
not. Oh, I wasn't done.
What? Yeah.
Okay.
What were you physically doing, Jack, when she walked through the door?
I was cleaning up feces.
Were you standing up on your knees, on your back? Where were you?
Again, Your Honor, respectfully, this was all covered in the case in chief.
You can answer the question.
Thank you. I was cleaning up Maya. I was cleaning the floor, just clean up everything, and along with taking her and putting her on the commode. But most of the time, it was too late.
All right. And in terms of the questioning, did she speak enough, the person who came in the white lab coat, so that later, by visual and voice, you were able to identify Sally Smith as that person?
Same objection, Your Honor.
Overruled. You can answer.
Okay. At first, there was no communication. In walked the person, and then eventually started asking questions with a raspy voice, like a cigarette voice.
All right. And what kind of, did she, without going into great detail, were these questions unusual from what you would expect from a doctor?
I thought it was an
Same objection,
unusual.
Your Honor.
Rephrase.
Well, I do believe there was testimony on this, so we really
Yes,
need
sir.
to move on.
I can move on. There was testimony in the record and some exhibits about your wife, Beata, explaining online in the first person for Maya. Can you tell us why that happened?
Yes. After seeing some of these notes or the emails, I realized this is probably why she was doing it. I'm from a family of eight children. My mom made a baby book for all of us. And in the baby books, it starts out, I got my first haircut, or I did this, or I crawled on such and such date. When Beata and I got married, she seen my baby book, and she thought that was an awesome idea. We got a coin from the year we were born and all different things in there. But after seeing the emails that Beata was doing, that reminded me of why she's probably doing that. She did baby books for the children too. Same way, I lost my first tooth on such and such date, things like that. She's talking for the child, and that's how my mom did it as well.
All right. Now, there's been testimony on direct examination in the defense case of whether Dr. Hanna referred Maya over to Johns Hopkins or to the Johns Hopkins ER, or whether you did. Can you tell the jury about that day and explain what happened?
Yes, I was the one that chose to go to the emergency room. Nobody told me to go there. I was in the Ronald McDonald House, which is on the grounds of Johns Hopkins property. I chose to go there. Nobody told me to go there. That was the closest facility, and that's the most severe. I see my daughter with abdominal pains. I don't know if you recall the week before, she had pains and I drove her there, but it was nothing like this time. and I'm the one that chose to take her there.
Very good. Now, if we could bring up 2277-253, please.
253A.
A, excuse me. All right. Do you see that there? Mr. Olson?
I do.
All right. Did there come a time when you directed your attorney to advise Johns Hopkins through the psychologist Jennifer Katzenstein about your concerns over Kathy Beattie?
That is correct, as you can see here.
And then in this, was your attorney stating what you had told them must be informed to Johns Hopkins?
Yes.
And through this period of time, did your wife, Beata, was she, at lack of a better term, in on this? Was she participating such that she knew what Kathy Beattie was doing?
She did know. Her attorney's also represented on this letter.
Okay. And so here you were advising about the fact that Ms. Beattie wanted to be on every supervised telephone call regardless.
Objection leading.
Sustained.
That is correct.
Yeah, well, I sustained it.
Oh, I'm
so
sorry.
I have to
Sorry.
It's okay.
ask a different question.
There was also with Dr. Smith a statement that Maya or you, in that same feces-driven episode, that Maya refused to be evaluated, or you refused Maya to be evaluated. Why was that?
Objection, it's not rebuttal.
Yes, it is.
Oh, you can answer that one.
Yes, there would have been no way for her to be evaluated at that time. Like I said, she had projectile feces coming, or just going everywhere, and there was no attempt for the doctor to make an evaluation.
And then finally, there were some snippets of depositions about your daughter's condition. Can you give the jury an idea about the variability of Maya's condition based on what was represented in those videos?
First of all, myself, I had 5 depositions. I believe Maya had 5 as well. So there's more to the story than what you've seen. She had a lot of bad days. Those little clips there, I'm sure, were the good days.
Okay. Your witness. Just one more question. You didn't really ever photograph her or video her on days when she was huddled in her room. Is that true?
No.
Mr. Shapiro.
Yes, thank you. Briefly. Good afternoon, Mr. Clausen.
Good afternoon.
Just wanted to ask you a follow-up question about Dr. Hanna. Do you remember him? You don't remember him referring you or Maya to the all children's emergency room?
No, I left Dr. Hanna's office with Maya. I took her to get something to eat before we went to the Ronald McDonald house.
Okay. Can we bring up what's in evidence as 3028001? If you can enlarge that a little bit. Take a moment to read it, Mr. Kowalski. I'll represent to you that the FSI is Dr. Hanna's office, and this is a prescription signed by him.
Okay.
The previous day, he was writing a referral for a nutrition consult, asking you to take Maya somewhere to get her nutrition checked out. Isn't that true?
I picked Maya up from his facility. Mom was with Maya at that time.
So if I understand your testimony, Mrs. Kowalski was told by Dr. Hanna the previous day to take Maya to the hospital. You weren't at this appointment?
I cannot say that's true or not, but I'm just telling you, I did not personally get this.
And I guess in fairness to you,
That would have been 10-6 that I had her. 10-5, Beata was with Maya.
I got it. So this prescription, this referral was given to your wife the previous day you weren't at this appointment.
I don't know if she received it, but 10-5, that would have been her.
Let me just ask you, turning to brighter news, just a couple photographs. Let's see if we can pick some dates on these because these are not dated, sir. 3138-0002. Do you know approximately when this was taken?
I would say May, I would say somewhere in the May of 23.
Okay, May to June of 2023.
That is correct.
Okay, let's just a couple more, sir. 3138-0005. Do you know approximately when this was taken?
That might have been a little before, but I would say 2023. I couldn't give you a month.
Okay.
I could be wrong on that.
To the best of your recollection, 2023?
Yeah, somewhere in that time.
Okay. Let me ask you about 3138-0007. And maybe you can enlarge it a little bit. Do you know when this was taken?
That'd be a good question for Maya.
Okay. Should I stop? I don't want to bother you. I was just wondering, is this homecoming 2022?
That I couldn't tell you.
Okay, I shall ask Maya. Let me ask you a couple more. 34041. Do you know when this was taken?
That would have been this year, homecoming.
Okay, like within the last week?
You would have to ask her the date, but it was very early, just not too long ago.
Okay, and let me ask you about one more, 34042. If you can expand that a little bit.
Self-explanatory on the bottom there.
Okay.
Homecoming 2023.
Was that within the last month, like during this trial?
Yes.
Okay. Only because it's been asked before, but does Maya look happy in those photos to you?
You need to ask her these questions because just by looking at her and saying she's happy, I don't want to speak for her because I'm not the one, but she could explain this much more in detail.
Okay. I appreciate your time, sir.
Okay, thank you.
Any further questions?
Just one simple question. There were a couple of photographs taken by a professional photographer, is that right?
That is correct.
Nothing further.
Nothing further, Your Honor.
Members of the jury, do any of you have any further questions, or any questions, I should say? Okay, Mr. Kowalski, seeing no questions, you can go have a seat.
Thank you.
Your next witness, please.
Or do you have the policy yet?
Do you want to talk outside the presence of the jury? Do you want to approach the bench?
You can approach if you will.
Approach for 1 second.
Dr. Joe Corcoran.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Mr. Whitney.
Good afternoon, Dr. Corcoran.
Good afternoon.
Of course, I hope the jury remembers you. You previously testified as the hospital management expert for the Kowalskis.
I did.
And your experience briefly includes as both a treating physician, and then after some time you became involved in hospital management through HCA.
That's correct.
And your time with HCA, you served as chief medical officer for approximately 10 years.
I was a facility chief medical officer for about 5 years, a division chief medical officer for 3 years, and that was overseeing 2 states, 8 hospitals, and 35 plus or minus sites of care.
All right, so we brought you back to discuss some particular issues that were raised in the defense's case. Have you had an opportunity, although you haven't been in the courtroom, to observe the testimony of certain witnesses?
Yes, I have.
Have you observed, did you have a chance to see or review the testimony of, for example, witness Mr. Anderson, the hospital management expert from the defense?
Yes, sir, I did.
Did you have the opportunity to review or observe the testimony of Dr. Paladis?
Yes, sir, I did.
And did you have the opportunity finally to review the testimony of Dr. Jenny Dolan, who testified yesterday afternoon?
Yes, I did.
And as we go along, and I don't think this will take very long, but as we go along, if there are other witnesses that the defense put on that are pertinent to your testimony, please let us know. Just let us know you've heard their testimony as well.
Of course.
I want to start with what the jury has seen on several occasions, and I'll put it back up momentarily, which is the corrective action notice for Catherine Beatty at Exhibit 2278-036. And Mr. Reyes, can you put up Exhibit 2809 side by side? So on the left side of your screen there, Dr. Corcoran, do you recognize the corrective action notice for Ms. Beatty and the date of the infraction of November 9th, 2016?
I do recognize this, yes, sir.
No, that's not the 2809 on the right side.
Hearing something that's a rebuttal as opposed to some
New testimony or rehash?
There's a question pending at this moment. So, did I miss the question? Just, if you're going to ask a question, ask the question then. I'm sorry if I missed it.
I don't think I had a question. I was talking to Mr. Reyes at the moment because can you pull down 2809 there for a second? That's not, 2809 was marked. This was marked as 2809. While we're doing that, do you recall witness Mr. Anderson testifying to Ms. Beatty's performance evaluations?
I do.
And the testimony was that she had met and exceeded expectations, correct?
Objection, leading.
Sustain.
What was witness Mr. Anderson's testimony on Catherine Beatty's performance evaluations?
Objection, Your Honor. He's just asking to regurgitate testimony.
I always see everybody up here for a moment.
In your roles with HCA, did you participate in disciplinary actions of certain people that reported to you as chief medical officer?
Yes, I did.
And you're familiar with the progressive disciplinary policies that are in place within hospitals?
Objection, are we vague regarding whom?
Yes, progressive elevation.
And so on the right side of your screen, we now have the corrective action notice for Catherine Beatty, and on the left side of your screen, we have the corrective action policy for Johns Hopkins All Children's Hospital during the relevant time, during Mike Kowalski's admission and during Catherine Beatty's discipline.
You're on objection to foundation and predicate. May I have order either witness?
You made one of it. So, Mr. Whitney, let Mr. Hunter take over the lectern.
Yes, Your Honor.
Good afternoon, Dr. Corcoran.
Good afternoon, Mr. Hunter.
As I understood your prior testimony, you served as chief medical officer at Brandon Hospital, correct?
Brandon Regional Hospital.
Brandon
yes,
Regional
sir.
Hospital. I'm sorry. It's right up the street. I just call it Brandon Hospital. Right to speak to me, I should say. And if I understand correctly, as chief medical officer, you had purview over the medical staff office, medical staff, and the quality assurance, correct?
Those were some of the areas that I mentioned. I also mentioned CPOE, computer physician order entry. I also was the executive in charge of graduate medical education.
Okay.
I believe that's it.
Okay. And then when you became regional
Division chief medical
I'm
officer.
sorry, I didn't have the terminology right. You were like a chief medical officer for the division over the other chief medical officers, correct?
And their teams, yes, sir.
And their teams. But you did not have authority over human resources.
Not the HR department, as I explained. Not the HR department.
Okay. So as far as the employees and their HR relations and disciplinary actions, you did not have authority over that, correct?
That's incorrect. I was responsible for my teams in the hospital and at the division level in the field at the various hospitals. So I was involved in at least 2 terminations of facility chief medical officers. So yes, I was responsible for building and rebuilding my teams.
Oh, okay, so your teams of chief medical officers.
And their teams, yes.
And their teams,
Yes,
okay.
sir.
When I say HR, I'm talking about hospital staff, doctors and nurses, hospital employees. I'm sorry, that was a horrible question. That question should be taken out in the shot. I was talking about, when I'm talking about hospital staff here, I'm not talking about medical staff. I'm talking about nurses, etc., nurses and social workers and employees of the hospital. Those folks are managed by HR, correct?
Well, no. HR serves a function in every employee's life at the facility. But those specialties, nurse, a nurse would actually be, if we're speaking about hiring, firing, they would be hired and fired by the chief nursing officer. Social work may respond to the chief financial officer, so they would do the hiring, firing. So there's always an executive with accountability for that department who is, and you frequently see that on an org chart. HR is there to, number one, highlight the rules. Number two, make sure that we all follow what we're supposed to be following.
And you did not have purview over HR?
I did not run, the HR did not report to the chief medical officer. That is correct.
There you go. Okay. And so the functions of HR and the functions of the chief nursing officer were not something that you had supervisory or executive authority over, correct?
Not over HR and not over the chief nursing officer, correct?
And you didn't have supervisory authority over the chief financial officer?
No, I did not.
Okay, and that would have included the social workers, correct?
I believe in our hospital, the social workers and case managers referred up to the chief financial officer. Correct.
Okay. So you didn't do the performance evaluations or supervise the performance evaluations for nurses or social workers, correct?
Right. I did performance evaluations on my direct reports.
Right. On your chief medical officers and their teams.
And the other departments that I had a hand in managing.
Right,
Yes, sir.
right. Okay. But not the nurses and not the social workers.
No, that we followed the same process because that was mediated by HR at both the facility and for us, the corporate level in Nashville. We followed the same process. They did the performance evaluations on their teams. I did performance evaluations on my teams.
Okay. But you didn't supervise them and you didn't run that process
And
for
they
them.
didn't supervise me. That's
right.
correct.
Okay. Thank you, sir.
We were colleagues at the same level, correct?
Thank you, sir.
Yes, sir.
Anything further, Mr. Whitney, on foundation issues?
There's an interaction between HR and you as the CMO.
Right.
In terms of you have to abide by the HR policy and ensure that when you're hiring, firing, disciplining employees, physicians, you're abiding by HR policy, even though you're not in charge of HR.
Overruled.
Yes, they were basically my ambassador to the process, and they were really the umpire that called balls and strikes to make sure that I was following the right intervention and that the employee was being granted the right protections and options.
So in your various roles, you made reference to the HR policies when you were enacting a progressive disciplinary plan for a staff physician, a staff employee, medical staff in your hospitals.
Correct. Typically, if I had a chief medical officer at one of my hospitals who wanted to terminate a member of the quality team, typically my first question was, what does the process say, right? Because we always need to make sure that we are following our process, particularly when it comes to discipline. Correct.
And if you had an opportunity to review what's here as Trial Exhibit 2809.
The corrective action
Policy?
Yes, sir.
And in looking at that policy, Dr. Corcoran, it talks to employees. Does it make any distinction between a corrective action policy for physicians, social workers, nurses, or does it just say all employees are subject to this corrective action policy?
Objection, Your Honor. Document speaks for itself. And I don't believe it covers that.
I never saw any distinctions or differentiations pointed out in the policy. No, sir.
I continue.
I'm sorry?
I'm done with those. If I can continue.
You may continue.
One moment. Oh, please keep those up. I didn't mean I was done with those documents, just those questions. All right. If we could turn to the second page of the policy here and back to the corrective action notice. I want to focus your attention, Dr. Corcoran, on paragraph B1 of the policy there on the left that talks about verbal counseling. And my question is, under the Johns Hopkins All Children's Hospital policy, was verbal counseling required to be documented?
Yes, it was. And the policy requires the supervisor will make a record of the verbal counseling.
And with respect to Catherine Beatty's corrective action notice on November 9, 2016, in the second box, is it apparent that Ms. Beatty was counseled on 2 previous occasions?
That's what it says. Kathy has been counseled on 2 previous occasions regarding professional behavior among colleagues.
And in your role here as the hospital management expert, have you had the opportunity to familiarize yourself with what's been produced as Catherine Beatty's personnel file?
I have reviewed it, and specifically the 2015, 2016, and 2018 performance reviews.
Sure.
I think a few minutes ago I'd asked you that you'd reviewed Kathy Beatty's personnel file, and you were, in general, you were familiar that she was counseled on 2 previous occasions. And having looked now at the policy of Johns Hopkins All Children's Hospital, does it appear that on neither of the 2 previous occasions were her disciplinary actions filed in her personnel file or documented in any way?
I've not been provided any documentation to suggest that they were written up as is clearly required by the supervisor to make a record of the verbal counseling. So if they exist, I've not seen them.
All right. I want to look at number 4 at the bottom there. It talks about an administrative leave being authorized to allow for a cool down period. In your experience with HCA, is a cool down period appropriate where an employee on the medical staff has documented anger management issues?
Objection, Your Honor. Relevance beyond the scope.
Overruled.
And 403.
Overruled on all those bases.
I think a cool down period can be very helpful when emotions are escalated.
And have you seen in reviewing a personnel file any indication that Ms. Beatty was subject to administrative leave or a cool down period?
Not that I'm aware of.
Turning to the next page of the policy, number 5. I'll just reference you for a second. Number 5, it says termination may be authorized after the preceding steps have completed, except for gross misconduct. So keeping that in mind, let's look down at E, which talks about gross misconduct. And seeing that, and then turning, if you could put up the next page, which continues with E. The top one includes engaging in fights or indecent, immoral, or abusive conduct while on all Children's Hospital's property. Having reviewed the corrective action notice of Catherine Beatty, and based on your experience, would you characterize what Ms. Beatty was disciplined for here as either engaging in a fight or abusive conduct?
Compound pleading, Your Honor.
I guess it is a compound question, so why don't you break it up?
All right. Same predicate. You've reviewed these documents.
Yes, sir.
Would you characterize Ms. Beatty's actions as described in this corrective action notice as abusive conduct?
Just give me a moment to review the specific language.
And if you need to see
Can you
the statement of specific misconduct,
yes, sir. Thank
top
you.
box.
Thank you. Thank you very much. Clearly, the witnesses were made uncomfortable by the situation. As they stated in the report, the witnesses reported that they asked for them to take it to another location and reported that Kathy was very loud and aggressive. I don't know how their HR department would define abusive, but that's kind of has been used before, threading the needle. I don't know if it meets the definition of abusive or not, but it's certainly aggressive, as documented in the
All right. To
report.
be fair, if I understand your testimony, what is documented in her corrective action notice may not rise to the level of gross misconduct. Is that your testimony?
It is.
All right.
It's darn close, but
Understood.
may not meet the threshold.
Understood. Let's talk about the Joint Commission and the role a Joint Commission plays in reviewing a hospital's performance.
Objection, Your Honor. Can I approach?
Sure. the jury, I'm going to need you to step outside for a couple of minutes. Do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
All rise. Jurors exit.
The jury is out of our presence. Mr. Whitney, I've now stopped the clock, but I need to hear what you're attempting to do.
Do you intend that I ask the witness questions, or we send him out of the room while we discuss this? I just want to make sure.
I would prefer the witness be excused, Your Honor. I'm just going to take a cue from this.
Well, okay. We're going to ask you to step out, but I might need you to come in and give me testimony outside the presence of the jury.
Yes, sir.
Is outside our presence. Mr. Whitney, what is it that you're attempting to elicit out of this witness on this line of questioning?
Yes. I'm attempting to elicit testimony in rebuttal to witness Mr. Anderson's statements that the Joint Commission had found that Johns Hopkins met and exceeded expectations during the relevant period of time while Mike Kowalski was hospitalized.
And met and exceeded?
Yes, Your Honor. And this witness has direct knowledge to the opposite. Through his role at the time at Brandon Regional Hospital, he participated directly in a call with senior counsel at Johns Hopkins All Children's Hospital, who explained that the hospital had been reviewed by the Joint Commission and was in the classification as immediate jeopardy. And these surveys, as their expert testified to, are conducted on a triennial basis. So
every 3 years or 3 times a year?
Every 3 years. And so when he learned of this, the look-back period included the time that Maya Kowalski was at the hospital and the time period in which they were found to be in immediate jeopardy.
On what basis?
His testimony will be that on a system-wide basis, there were programmatic failures that led to patient safety issues. That's his testimony. And as I mentioned at sidebar, I've instructed him to stay away from specific mention of the Heart Institute issues because I know that's a sensitive issue. But the classification received by Johns Hopkins All Children's Hospital by Joint Commission is fair game because their expert came in here and testified to the opposite.
Okay, I need to understand better where or how this immediate jeopardy alleged finding, what's it based on? Because this has the potential of causing problems with this trial on appeal. So let's be clear as to what it is that you are trying to assert here.
I'll try to articulate it as best I can. The Joint Commission issues certain ratings classifications for hospitals upon their review every 3 years. In this instance, in 2017, when they were looking back at previous 3 years, they found that this hospital deserved the classification of immediate jeopardy. I'm happy to answer questions. I don't know what else I can say.
What generated the immediate jeopardy finding? If there is such a finding.
Yes. Well, here's the dilemma. Their expert testified that he had based his testimony upon summaries or outlines provided by defense counsel to him. I have the testimony. The Joint Commission...
It's Mr. Hunter.
The Joint Commission reports were not provided, not even to their experts. So the jury is left with a false impression based on the outline provided by defense counsel to the expert that they passed with flying colors.
Do you have any written documentation that would suggest that there's an immediate finding?
Yes, we do. And in fact, in his direct testimony, previously when he attempted to touch on CMS, Center for Medicaid Services. He was excluded from doing so because defense counsel still objected that this was referencing federal regulatory agencies. And then, on direct examination by defense counsel, they asked, so I want you to explain what the joint commissions are, but is all children's audited by federal agencies to ensure that they are in compliance with federal safety plans? So then they introduced the concept of federal agencies. So Mr. Corcoran, Dr. Corcoran, is in possession of CMS findings wedded to this joint commission audit that have specific findings. Again, I wasn't going to put all of that in front of the jury. I was going to keep it at a relatively high level. But I understand the court's inquiry.
Well, is the alleged immediate finding, is that having to do with something having to do with the Heart Institute?
Yes.
It's the best I can phrase that, and we could ask Dr. Corcoran's question because he's much more knowledgeable about this, is that it's a programmatic issue. It does not say Heart Institute isolated issues in the documents that he has. It does not say that.
Hey, Mr. Hunter, first off, can you help me understand, was Johns Hopkins All Children's Hospital under some sort of immediate threat finding by the Joint Commission?
I'm going to tell Your Honor what I know, and since I was not, I don't know what documents.
Aren't you the general counsel of the hospital? Or
I'm
outside counsel?
I'm outside counsel, but I don't know all. I'm not general counsel. Okay.
I apologize, but help me understand, was there some sort of...
There was a finding of that sort, and I don't know the specifics of it, or at least I don't have them off the top of my head. There was a finding of that sort that was made that was a direct and virtually exclusive result of the issue over the Heart Institute. And that was the driving force both behind the inquiry and behind the findings that were made. And that was what the findings were based upon, as I understood them to be, Your Honor.
And is this during the relevant time period?
It was during... It was in part during the relevant time period.
Let me make sure I understand. Did the defense adduce evidence to have your witness bless the hospital and make it appear to the jury that everything was hunky-dory with the Joint Commission?
I don't believe so, Your Honor, but I was not in the room when Dr. Anderson testified.
I'm going to take a 5-minute break. 5 minutes.
All rise, it's for the recess.
can be seated. Everyone's back. I need to understand if this finding was specific to like a department, or if it was more diffuse and more systemic to the whole organization. So I need testimony on that.
Understood.
Let's bring them on.
I'll be right back.
And we're doing this outside the presence of the jury. Let's have this witness come and say what he's going to say. Yes, come on down. Mr. Whitney will go first, then Mr. Hunter will ask questions.
And the inquiry is limited to what the findings were.
What this is. I mean, just get to it really quickly because we're out of
Absolutely.
time. But
Understood. Dr. Corcoran, through your investigation of Johns Hopkins All Children's Hospital and your role at Brandon Regional at the time, is it true that you became aware of the Joint Commission findings for the relevant time period? Of Maya Kowalski's...
let him ask the questions. You'll get a chance, Mr. Hunter.
As a result of the investigation for this, yes, I became aware that there was an IJ, or an immediate jeopardy.
And you've reviewed documents, although you haven't had access to the Joint Commission, you have access to, tell us what you have access to that you've reviewed, please.
So the only complete document was one that was presented in the newspaper, and that was the follow-up to the September Joint Commission visit where the immediate jeopardy was issued, and that...
But to be clear,
yes, sir.
You're not saying you only looked at a newspaper article.
No, they...
What document did you look to?
The newspaper printed the copy of the full 51-page report.
All right. Now, having reviewed that report, the primary question at this point is, can you describe what the specific findings were? And I'll direct you a little bit in that, were these hospital-wide issues, or were they limited, and we're outside the presence of the jury here, or were they limited to solely the issues with the Heart Institute that were covered in the media?
So I will tell you that an immediate jeopardy penalty or threat is issued when the problems are widespread and egregious. So typically that that kind of a threat, as high impact as it is reserved for systemic failures.
So when you say that, do I understand you mean that it's not limited to the pediatric cardiovascular surgery unit? When an immediate jeopardy is issued, and based on a review of the 51-page report, it's speaking to widespread issues within the hospital or hospital system.
Right. The adjectives that are frequently associated with IJ is widespread and egregious. And so by definition, it can't be an isolated occurrence to that happens once.
And within that document, were there also certain statements that were more or less acknowledgments by hospital leadership of the programmatic and widespread failures?
There was acknowledgement in the document itself that came out of an exit conference with I believe he was interim CEO at that point, came down from Baltimore, and he acknowledged that, and I don't have the quote because I don't have the document, but he acknowledged that their failures contributed to, I can't remember the exact term, but basically let patients down.
All right. just moving
Go ahead, I'm sorry, go ahead. I'm sorry.
moving away from that quickly, and if the court wants to cut me off, I'm sure it will. With your specific experience at Brandon Regional Hospital, you had a specific conversation with senior counsel at the hospital at the time regarding these findings, did you not?
I did.
Who did you speak to at Johns Hopkins All Children's Hospital?
I was on a call with my CEO and with Jackie Crane, senior counsel at All Children's.
And through that phone call, is it true that she confirmed the findings of immediate jeopardy? Is that right?
Correct. She confirmed the findings of IJ and expressed optimism that their corrective action plan would be accepted.
And so this is typical as well when a joint commission comes like this, you have to develop a corrective action plan.
That's correct.
All right. And I just want to set up the reason for the call. If I understood,
Yeah.
your testimony in our case was that you had a partnership or an affiliation with Johns Hopkins All Children's Hospital. And so was it true that your concern and the reason for this conversation with Ms. Crane was that it might have impacted your hospital?
That's correct. As I testified earlier, we worked with Jackie Crane, we worked with Dr. Napolitano and others to help us build out not only the infrastructure but the talent to support the pediatric hospital within the hospital. If their IJ was going to be a factor for them, our concern at Brandon was that would this disrupt our operations of the pediatric care being administered?
All right. I will leave it there for the moment.
Mr. Hunter, any questions for this witness?
Yes, sir.
The document that you reviewed was printed in the newspaper?
The survey document was made available through the newspaper, that's correct.
Which one?
Tampa Bay Times.
And what period of time, well, when was the September review that you referred to? What year?
September 2018.
2018.
2018 was when the IJ was cited, was issued.
Okay.
And the follow-up survey that was published in the Tampa Bay Times was dated, memory serves, January 11, 2019. So about 2 months later.
Okay. So
I'm sorry, bad math. 4 months later.
Okay. So the survey you're referring to occurred in 2018, and the follow-up was in January of 2019.
The follow-up visit in the first full week of January. I believe the visit dates were January 7 through 11, 2019, and that survey was, in the explanation for the survey, was in follow-up to the IJ from September of 2018.
Okay. And the report you're referencing came from who? From JACO or from CMS?
I believe that the follow-up survey was a federal survey, CMS.
So the follow-up survey was CMS. What was the original survey, do you know?
I didn't have access to it.
Okay.
But IJs are typically issued by the Joint Commission during their triennial surveys or other surveys.
Okay, so you're not really sure who the IJ was issued by?
That's correct, because I don't have that document.
Okay, and you're not, but you do know that the follow-up was from CMS. But have you ever seen the actual report of the follow-up?
Yes, sir. They published the 51-page report.
Okay. So you saw the follow-up report?
That's all that I had access to, yes, sir.
Okay. So you never saw the actual IJ report?
I never saw the September 2018 IJ report.
Okay. So you don't know what dates that IJ report covered?
Well, the IJ report, or the IJ that was issued, came out of a September 2018 report. If it was part of the Joint Commission survey, and that occurs every 3 years for accreditation, then it would have been the 3 years leading up to September of 2018, taking us back to 2015.
The The operative word in that sentence is if. Do you know that, one way or the other? Not having ever seen the report?
No, sir.
Okay, so you can't tell me, can't tell this court for certain that that report was either A, joint commission as opposed to somebody else, or B, what dates it covered?
I cannot tell you with a 100.00% certainty that it was a joint commission survey. I can tell you that the overwhelming probability, because of the timing, because of the finding of the IJ, that typically would come from a joint commission visit.
Okay,
But 100.00%, I cannot attest to that.
you've never seen the document.
It's not been made available to me.
You've never seen the document, and you don't know what dates it covered.
It would cover up to the September visit that resulted in the IJ would cover the period immediately preceding, and in joint commission evaluations, they are 3-year lookbacks.
If it was joint commission.
That's what I said, sir.
All right. Do you know what the basis specifically was for what you're referring to as the IJ in September of 2017? Never having seen the report.
The IJ, the character of the IJ was referenced in the first 3 paragraphs on page 1 of the January report. May I refresh my recollection of what that addresses?
I thought you said you didn't have the report.
I don't know, sir. You're not. Perhaps I'm not being clear today. I have the January 2019 report, which in the first 3 paragraphs, left top on page 1, addresses the immediate jeopardy, because that's the reason for the follow-up visit in January of 2019. It addresses the IJ and as the reason for the follow-up visit. So what I don't have, sir, is the September 2018 report.
So what you reviewed would tell you what the 2019 report said about the 2018 report that you haven't seen.
The first 3 paragraphs of the 2019 report reference back to the IJ being issued in September of 2018. I do not have access to the 2018 report.
Anything else, Mr. Hunter?
I think that's it, Your Honor.
Sir, if you could go step outside for a moment.
Yes, sir.
And Mr. Shapiro, did you say you had the transcript from the testimony of your expert
Thank you, Your Honor.
that addressed this issue?
If you would like me to, Your Honor, yes. Towards the end of his testimony, let's see.
Can you just hand it to me? Sure. Point me to a page or pages. Yes. So starting on page 19. I'm assuming this is an excerpt from Anderson. I've read pages, I guess it's pages 18, 19, and 20.
And then there was a sidebar conversation. And then,
Well, at this point, I'm just concerned about what was referenced to the jury. and the impression left with the jury.
Yeah, it was something volunteered by as you can see, for whatever reason, he volunteered some information. He was not provided. I don't have the data. He wasn't provided data. I think he's speaking generically about the fact that hospitals need to be accredited to accept funding, but and for whatever it's worth, well, anyway, that's all I'll say. I think Mr. Hunter's proffer established that whatever this witness was talking about was 2018, 2019, but.
So, I'm asking the defense, was there an immediate finding issued by the Joint Commission?
Not in 2016, no.
Well, it was 2018 that had a cover a 3-year.
It was related to the HEART program, Your Honor, in 2017.
So the answer is yes, there was an immediate finding.
Well, that I don't know. I don't have the document in front of me, Your Honor.
Well, let me tell you where we're going to go with this.
Okay.
Most likely, if we can't come to an agreement as to how to handle this right now, I am going to direct the hospital to turn over all this information to the defense today, and then you're going to have a corporate rep sit for this, probably tomorrow or the next day. We will not close the evidence, and then we'll go for it. Because my reading of this transcript is the hospital has given the impression to the jury that everything was fine. And I'm being presented with evidence that during the relevant period of time that your expert testified that it was fine, that it wasn't fine. Now, if it is specifically only to this one specific department, it probably is not relevant. But if it is a systemic problem at the hospital, that is relevant and it is a proper rebuttal case evidence. So either we can come to an agreement how to deal with this right now, or the hospital's getting a corporate rep for a deposition and we're not finishing today. Y'all want to take 5 minutes and talk amongst yourselves as to how you want to proceed.
All rise. Scores in recess.
somebody can go find the defense counsel, please? Mr. Hunter.
We're trying to gather details, Your Honor. So I'm going to tell you what I know so far, what I've been told. And we'll try to, I would like the court's indulgence to investigate this further, to piece it together. But what I've been, because I've got a bunch of details about this in my closed files that I don't have off the top of my head. The long and short of what I am being told at this point is that the IJ to which the witness is referring was not the result of a JCO triennial review. It was the result of a self-report that Johns Hopkins All Children's made regarding the Heart Institute, and the outcomes that were being reported resulted in the IJ before JCO ever came on site. Now, my understanding is, from what I'm being told, that it was the result of the Heart Institute and the outcomes in the Heart Institute, which I can tell you were bad. But the issue that was being addressed in the JCO IJ was indeed issued in September of 2018, but again was not from a triennial report, but was from a self-report. And then the CMS report in January was indeed in a follow-up to that. Now, there are phone calls being made. I'm trying to get the details verified because I don't want to mislead Your Honor in any way. I'm trying to tie this down as quickly and as efficiently as I can. But it is something I need a few minutes on.
Well, again, if whatever this is was limited to the heart department, whatever we call the heart department, I don't think it has anything to do with Ms. Kowalski.
That has been our position from the outset, Judge, and I thought I buried this Dracula several years ago, but I did handle a bunch of those things, and I know the dates, but I don't have them.
So, again, obviously I want to finish evidence today. That might not happen, but if ultimately this is a more systemic issue, it's going to come in if it touches on the relevant time period. If it's conduct that occurred post the Kowalski stay or does not have some sort of reasonable tie back to the time, then it's not relevant. Okay? But is there anything we can do further with this witness, and we can just finish him off and then let him come back later on today or Monday if necessary? Because there's other witnesses, and let's get everything as much as we can do.
I had one other area of inquiry outside of the Joint Commission stuff I was going to discuss with him, and that'll be quick, and then we can send him home today, and then we can call other witnesses
here, and we can put Elena Kushner on, and then my end will be done.
Okay.
Well,
subject to, obviously.
If this witness would mind staying, because if there is some sort of resolution of what happened and what this report, I know you might have to take their word for it. I don't know if that's going to be acceptable or not, but maybe they'll turn around and say it was more systemic and it's fair game. Maybe they won't. I don't know.
I have the CMS follow-up report in front of me, and it does not even in my review here, utter the words Heart Institute. It's systemic, but we'll wait to see the 2018 that preceded this.
We'll have motions.
Well, this thing kind of exploding on me on the last day of testimony. Look, the last thing I want to do is to make a wrong call on this issue, because this issue has the perspective of causing this whole thing to be done over again.
We understand the court 100%, and neither do we in any way, shape, or form. So whatever the court thinks is necessary, that's what we're doing.
Well, that's what I think is necessary. And if this witness, let's finish him off with exception of the JCO and that other policy. Have we gotten the other policy yet? The one that was in archives?
To tell you the truth, Stretch, I forgot all about that.
Well, I've emailed no. The answer is no, I don't have anything additional.
Okay. So perhaps the witness will be able to stay around. Can you go ask him if he can stay and or come back on Monday if...
He lives in Sarasota or Tampa, so I think it won't be a problem to come back, but let me check.
Well, perhaps let's ask him.
Your Honor, the witness can stick around this afternoon, and he could be available Monday. He has a doctor's appointment in the afternoon, but I assume we conclude in the morning.
It'd be first thing in the morning, if we have to do it. Let's bring in the jury. Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Correct. No one approached you, correct? Correct. And no review of any media. Is that correct? Correct. Mr. Whitney, you may continue.
All right, Dr. Corker, we're going to move away from the Joint Commission, and you may come back later, but we'll see. Let's talk a little bit about the Medical Executive Committee. If we could put up Exhibit 2142, please. Alongside Exhibit 1079-0028. In your experience as a healthcare executive with HCA, are you familiar with the function of the Medical Executive Committee within a hospital organization?
I am.
Your Honor, please the court. This is not rebuttal.
Overruled. You can continue.
And I also served on the MEC when I was in private practice for 4 years.
All right, so what years would those have been? Approximately.
1999 to 2003.
All right. What is the function of a medical executive committee within a hospital?
So as I testified earlier, the medical staff is self-governing. The medical executive committee.
I'm sorry, I must object. This is not rebuttal. He's already testified about this. This was not anything that was raised by the defense in the defense.
You may continue, Mr. Whitney.
So the medical executive committee is the executive leadership team for the broader medical staff, which can number in several hundred members. So typically there's about a dozen department chairs and other elected positions that function as the homeowners association for the for the medical staff.
All right, and so if we look at 1079-028 on the right there, section 7.1-2 responsibilities, and these were discussed yesterday. The medical staff executive committee's roles include C and D. If you'd highlight C and D there, please. Do those responsibilities of the medical executive committee match with your experience?
Please, Judge. I'm so sorry?
May we approach?
Yes. You may continue, Mr. Whitney.
The pending question was, do C and D, or the responsibilities of the medical executive committee at Johns Hopkins All Children's Hospital, match with your experience?
They do.
And can you expound on those a little bit for me? Try to put it in terms that I'd understand, please.
Yeah, sure. And as I was explaining in my original testimony, there are issues that the medical staff and the hospital administrative leadership and the hospital board, which is ultimately accountable for all operations, all progress. So the medical executive committee acts as that point of contact for the hospital leadership and the board leadership.
All right. If you could zoom out on that page. And then briefly, I just want to list some names here. If you could highlight these for me, Mr. Reyes. Joseph Perno, Anthony Napolitano, Jenny Dolan. You had the opportunity to hear Dr. Dolan's testimony.
I did.
Michelle Smith, Suzanne Jackman, Diana Young, Mark Cavett, Anthony Kreisman, Dipti Amin, and then if you would highlight Jonathan Ellen, president, and Mark Stroud, chairman of the board. Is it your understanding that of those names I've just highlighted, 7 of them had treated Maya Kowalski at one point or another at Johns Hopkins All Children's Hospital?
I will take your word for the number, but there certainly are a number of treating physicians listed as members of the MEC, yes.
What does it say to you about the operation of this hospital that on the medical executive committee, comprised in part of 7 treating physicians, the issue of Maya Kowalski's hospitalization and her repeated complaints with risk management was apparently never discussed by the medical executive committee?
Objected, argumentative, Judge.
Overruled. You can answer.
Thank you, sir. It's hard to imagine that a case that was this unusual didn't ping enough of the parties that were taking care of Maya in the hospital, that this never got escalated, talked about, awareness. We heard Dr. Perno, Dr. Napolitano, they never heard of this case. And this would have been a fantastic opportunity for the MEC to step up to its responsibility as overseeing quality assurance and performance improvement for the medical staff, and to share that information with Dr. Ellen and Mr. Stroud. So that it was really being talked about, again, at a system-wide level.
Based on your experience, would you expect within your hospital that if you had 7 treating physicians on a case as sensitive as this, that they would make sure that both the president and the chairman of the board had heard of this to the medical executive committee?
Same objection, Your Honor.
Overruled. You can answer.
I think certainly the CEO president should have heard about it. I've always been blessed with boards that are very involved and active. So in my facility and my facilities, I would have expected the board to be notified as well.
Based on your background, training, and experience, and your review of the records, do you have an opinion as to, and given the sensitive issues with Ms. Beatty's disciplinary history and Maya repeatedly raising issues to risk management, do you have an opinion to a reasonable management probability that the failure of the medical executive committee to address this caused or contributed to the harm of Maya Kowalski?
Objections beyond the scope, argument of.
You can answer.
Thank you. I do believe that this failure on the part of the governing body contributed to why we're here.
No further questions at this time. Thank you.
Thank you.
Mr. Hunter.
No question this time, Your Honor.
Members of the jury, do any of you have any questions? Okay, without any, if you could wait outside.
Yes, sir.
Plaintiffs, your next witness in rebuttal.
Elena Kushner, and interpreter.
The oath to the interpreter first.
Stand here, face the clerk and raise your right hand.
Who's the interpreter? The interpreter.
Do you solemnly swear or affirm that you will make a true interpretation of the questions asked and the answers given, and that you will make a true translation into English of any writing which you are required by your duties to decipher or translate?
I do.
Now let's swear in the witness.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I wrote this one.
Please state your name for the record.
Elena K.
And where were you born?
В Украине.
In Ukraine. And where do you live now?
Венес, Флорида.
How long have you lived here?
8 лет.
8 years. All right. Now, just so the jury knows, do you have a son with a claim involving Nika, neurologically impaired?
Да.
And I'm
Yes.
your attorney in this?
Да.
You just asked me.
Let's just go, but.
Yes, sir. Yeah. Were you ever at Johns Hopkins All Children's Hospital for treatment for your son, William?
Да, были.
Yes, I have.
Do you remember meeting someone that, though you didn't know who they were at that time, you found out later was Sally Smith, Dr. Sally Smith?
Помните ли вы, что встретили кого-то, вы не знали, кто это был, и потом вы узнали, что это доктор Сэлли Смит?
Да, было.
Yes.
All right. Tell the jury what happened when you first saw this person that turned out to be Dr. Sally.
Когда я ее увидела, это была женщина немолодого возраста. Она пришла в белом халате.
When I saw her, it was a woman, not very young. She came in a white gown.
All right. And did she start asking you questions?
Да.
Yes.
And did she ever explain who she was?
Нет, она сказала, что она доктор, который работает в госпитале.
No, she said she was a doctor who was working at the hospital.
I see. And can you describe for the jury what she was wearing?
Она была одета в белом халате
She was wearing a white gown.
с надписью госпиталя.
Did it have any type of insignia on it, if you remember, even colors?
Да, это был обычный белый халат, который все доктора там носили.
It was a regular white gown, so all doctors were wearing it there.
С надписью John Hopkins Hospital.
And it says John Hopkins Hospital.
Did you later learn that this doctor you met was in fact investigating you?
Можно сейчас повторить?
Мы узнали позже, что этот врач, которого встретили, была на самом деле, она расследование проводила.
Да, это было позже.
Yes, it was later.
And how long was it before you were able to identify this person that came in investigating you in the white gown to find out who she really was?
Это было пару недель спустя, и нам это сказал наш адвокат на тот момент, который вел наше дело, что она приходила и с нами беседовала.
It was a couple of weeks later. We were told about it by our attorney at the time, that she came and was talking to us.
And your attorney identified this person to you? So,
Да.
I'm sorry. Yes, yes.
Let's move on.
Were you able to confirm that this was Sally, Dr. Sally Smith?
Да.
Yes.
Your witness.
Good afternoon.
Здравствуйте.
Good afternoon.
Does Mr. Anderson represent you?
Да.
Yes.
Did he ask you to come here today to testify?
Он попросил вас прийти сегодня.
Ну, нам сказали, да, что проходить свидетелем по делу.
Yes, we were told that we would be witness in the case.
Were you given a subpoena to come here?
Нам дали в повестку, чтобы пришли.
Да?
Yes.
Oh, yeah, thank you.
Anything further?
No, Your Honor. May this witness be...
Well,
Oh,
members
I'm
of
sorry.
the jury, do any of the members of the jury have any questions? Seeing none, ma'am, you're free to go. Can she be released from all subpoenas? Yes, she can be released.
Oh, they're not? Oh, yes, yes, please.
And the next witness, please.
Your Honor, I had the previously discussed video. Counsel, can you come up to that? State your name for the record.
Maya Kowalski.
And were you here in the courtroom, Maya, when some clips were played from your depositions?
I wasn't in the physical courtroom, but I did hear them, yes.
You did see them. And how many times were you deposed?
I believe 5.
5 times. And did those snippets show the overall view of what your life is like?
Absolutely not.
Well, the jury needs to know. So tell them what's going on.
With my health?
With what?
With my health?
Yes.
Yes. For the past couple of years, I haven't been pain-free. That's the reality for most CRPS patients. I go through periods of waxing and waning, so there'll be some periods of time where I'm doing generally better, and then other times where it's pretty severe. Fortunately enough, I haven't been nearly as bad as I was in 2015. However, that doesn't mean I don't suffer.
And I gather you don't pose for many pictures or have many pictures taken of you when you are having one of your relapses.
No, I don't really like to take pictures when I'm in pain.
And did you have a relapse then in November of 2020?
Yes, I did.
And did that put you in the hospital?
Sustained on that.
And so, if we could, I'd like to go through a couple of questions I think the jury has. Were you moved from your room to a surveillance room or left in your room to be surveyed?
Your Honor, this was also covered.
Overruled, you can answer that.
So I was first put into the emergency room. From the emergency room, I was moved to the PICU. Now, for a couple of days when I was in the PICU, there was no surveillance camera. However, then there was, but only for the 48 hours. But that wasn't really accurate because I was in the PICU for longer, and there's things that happened in there that were not on camera.
Then I'd like to clear up some questions about your dress during the photographs, if you're up for it. Can we bring up 2604-002? All right. Is that a picture of you?
Yes.
And what do you have on?
In this picture, I'm wearing blue shorts, and not pictured I was wearing a pink shirt before it was taken off.
All right. And then let's look at the next photo, which is 018. And what is that?
This is the bra I had underneath my pink shirt.
All right. And so well, let's look at 004. I'm going to ask you if that was the T-shirt.
Yes, that is the pink shirt I was referencing.
And what do you wear that for?
These are my pajamas, so it's something I would have put on the night before, woken up in, and then got changed into a different outfit. In this case, I was changing into my court outfit.
And just so the jury is aware then, let's pull up 022. And are those your feet during this?
Yes.
Is that your dystonia?
Yes.
Then let's turn to 2604-006. All right, now, you're in a different outfit here.
Yes.
What are you in?
I'm in a new bra. This is a white bra. And then I was in pink shorts that I wore underneath the dress that I would be putting on for court.
All right. So how did you get from your pajamas into this?
The nurse that was assisting Kathy Beatty in the photography session, she took off my clothes in front of Kathy Beatty, not in the absence of Kathy Beatty. She was most certainly there. She never left the room during this process. But the nurse was the one who assisted with putting the shorts on, removing the Shopkins bra, and putting this white bra on.
And how did you react to that?
It was one of the worst experiences ever. I mean, I'm a very private person, which has been brought up multiple times throughout this trial. And to be held against your will, being forced to take off your clothes in front of these strangers, essentially, it's extremely uncomfortable. I don't think I can convey to you how traumatic that was.
Now, there's some question about who was in the room. If you look at one's up there, 006, there appears to be 2 hands you're holding, and it looks like a person of color there, and both of them, or?
Yeah, respectfully, this is no longer rebuttal. This was going to
This was an issue on
Overruled.
This is the nurse that was helping Kathy Beatty.
Okay. Was there, and let's go back then and compare to the photograph with you having your shirt pulled down, 2604-004. Now there's one. Is that your hand there?
So the 2 hands closest to the left are my hands, but then there's a hand on the far right of the picture, which is not my hand.
Okay. And so who was that? Was that the nurse person?
Well, looking at the hands, it does not appear to be the nurses. To my recollection, this would have been Kathy Beatty, because there's no third person in the room.
You remember there were no third person in the room?
I wouldn't, if I was there, I don't remember a third person.
Well, all right. Now, you first came in, what did Kathy Beatty do in terms of touching you?
Well, when Kathy Beatty first came in, she came in alone to explain that if I wanted to go and see my mom, and if I wanted to go and see her at court, that the photos would have to be taken.
All right, and so, and this goes to the 3.
This is appropriate rebuttal overruled.
And so, she did touch you during that process of the clothes coming up?
It appears so, yes. Even though she has said that it's not her hand, it most certainly isn't the nurse's, and there wasn't a third person, so it has to be her hand.
All right, so is it because it's the person looks older?
Correct.
But even before this, Kathy B. assisted in disrobing you the first time?
Yes.
Now, about having 2 sets of photographs, let's show you 005. And prior to this, have I shown you these photographs to see if we can figure this out?
Yes.
All right. Now that's you. Is that one of the lesions there?
On my forehead, yes.
All right. To the best of your knowledge, when was this taken in relationship to the other photographs?
This photo, to my best recollection, was after the court hearing. So this is the photo that they're talking about with the second disrobing, but this was not a disrobing. It was just a picture of me in the wheelchair. I would have remembered a second time going through the process of disrobing. The first photos that we saw were from the same disrobing session. This is apparently the second session, but I wasn't stripped.
Do you have any real memory of this?
I don't have much memory of this, but I know that there was a photo taken. Again, I just didn't attach significance to it because I wasn't disrobed.
And whether you were stripped or not the second time?
Correct.
That was affecting you. All right. And in this photograph, although it appears to speak for itself, does this What are you feeling at that moment?
You could tell I'm not happy. I'm looking down. I'm not smiling. I look uncomfortable, as I was.
Now, when you first arrived over at Johns Hopkins, or within the first week, did there come a time that you were interviewed by a psychologist, Dr. Lewis?
Yes.
In his report, he has a number of statements attributable to you. Have you read that report then?
No, I have not.
Have you been told those statements that came from the report?
Yes.
Did you make those statements?
No, I did not.
And were those, how did that come about then, that there were these specific statements?
I remember this interview with Dr. Lewis very well because I was crying, and by the end of it, I left crying even harder. He would suggest things for me to say, and then he would proceed to write down what he had just stated, even though I did not agree to the statements.
And was that true of all of those statements where you were supposedly describing your life?
Yes.
You did not tell him those things?
Correct. I would not say things like that.
Okay. There has been some testimony about you using cursive language in the days there. Were you on steroids at the time that you came in?
Yes, I was on steroids.
And how much do you really remember of that first 36, 40 hours?
I don't remember it all too well, if I'm being completely honest.
Okay. And then was there a point where they had you, or that they put a tube through your nose?
Yes.
And so how did that affect you? I'm trying to put that thing down here.
So it's been brought to my attention that, but people have said that Kathy Beatty was the one who explained the situation of my dad having to leave. That's not true. My dad was the one at my bedside. I woke up and he was crying. I've never seen my dad cry in my entire life, so I knew something bad was going on. That's when he told me that he had to leave. Again, at the time I had a tube down my nose and it has been freshly placed, so that went through my throat. I was crying. I could barely get out a couple of words because of how bad my throat was hurting. So there's no way I would have been able to yell at the medical staff, cursing at them and calling them profanity names.
Do you ever use cursive language to your knowledge?
At that time, I did not.
During the times when you were allowed to talk to your mom, tell the jury whether Miss Beatty was there or left the rooms at any point.
Miss Beatty was always there. She made certain she was the one holding the phone. She made certain she was right next to me on the bed. She had to be there.
And do you remember a single call any call where Miss Beatty just left the Children's Life
There was
contractor, or was Miss Beatty on them regardless?
No, there was no other people assigned to monitor the phone calls with me there in person. It was always Kathy.
So when you were talking and there were other people monitoring, they were either calling in or somehow joining to the call?
Correct.
So was it during these episodes where Ms. Beatty would make facial gestures or comments that were upsetting?
During the unrecorded phone calls, that is when she started to make comments, and again, the facial expressions, as you have mentioned.
Now, the jury has been read in order about your visitation rights and so forth. I just want to tell you, in the last 2 weeks or so, after December 27th, before your mom passed, were you allowed any calls, daily? It's a daily video calls?
No. I didn't even know I had that privilege. It was not told to me.
Your witness.
Mr. Shapiro?
Yeah, very briefly. Hi, Matt.
Hello.
Just so I understand your testimony, you came back from court that evening around 6:30 or 7 p.m.?
I don't know the exact time that I came back, but I know that that photo was after court.
Court ran somewhat later in the evening. Would it sound about right that it was around 6 or 7 at night?
Possibly, yes.
Okay. What, Mr. Reyes, what photo was that you showed?
Five different photos.
It was posted.
2604.
Yeah, the last one in the wheelchair.
Here's five.
The 5? Can we put up 5? And this is the photo that you contend was taken in the evening when you came back?
I know it was a photo of me in a wheelchair. Am I positively certain that this is the one? No, but I know that it was a photo of me in a wheelchair. There was no disrobing the second time around.
Okay. And at some point in the evening on January 6th?
Yes.
Okay. That's all I have. Thank you for your time.
Mr. Anderson, anything further?
Nothing further.
Members of the jury, do any of you have questions? Kowalski, there's a couple of questions. Do you know what happened to the photo after court, and did they take a second set of photos, and did they take clothes off?
So that's why in my previous testimony I said that there was no second set, because the second set would have involved disrobing, but now I know that the second set was just a single photograph of me in the wheelchair and no clothes were removed.
And Mr. Reyes, please pull this up, the 2604-006 photo. Is this the, quote, before, end quote, you went to court?
Yes.
The 2604-004 photo, is this in the same photo session before court or after court, or when was this taken?
This was the same as the before. So there is two different outfits, but that is because I was changing from my pajamas to my court clothes. But it was all before court.
And Mr. Reyes, if you pull up that last photo, which is 2604-005, the one where you're sitting in the wheelchair, is this an after court photo?
Yes.
Mr. Anderson, any follow-ups?
I don't think so, Judge.
Oh, no, thank you, Your Honor.
Anything further from the jury? Okay, Ms. Kowalski, you can go ahead and have a seat with your attorneys. Members of the jury, we're going to take an afternoon break. It'll probably be 10 to 15 minutes. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
All rise. Jurors exit.
Okay, the jury's out of our presence. Plaintiffs have consumed an hour, 10 minutes in their rebuttal time. Why don't we take a couple of minutes and the parties can readdress the policy issue and then also anything further on the joint commission matter. How much time do you want me to give you? 5 minutes, 10 minutes? 10 minutes it will be.
All rise. Court's in recess.
Ms. Kowalski wants to explain the homecoming pictures.
Take 2 minutes.
Before we get to that, let's talk about the policies and the Joint Commission issue, if you have any further update.
Yeah, yes, Your Honor. On the last remaining policy they were looking for, my client triple checked. The older policy was put into an archive system that no longer exists or that they have access to. So I have no more policies to produce. On the Joint Commissions, there was a Joint Commission triannual survey done in, I believe, August 2018 that the hospital passed. The IJ, that they were talking about was related to the Heart Institute, that was separate and apart from the triennial survey.
And we're getting that, sir.
Okay.
Yeah. If he needs it.
What do the plans want to do? Because, look, here's the policy. Does that really matter at this point? And I guess the bigger question is, are you going to press the Joint Commission, or are we?
So, yes. So, speaking to the policy first, as long as we can get a stipulation that annual performance reviews were required in the hospital policy, we don't need to see the policy. Alternatively, we adopt the 2018 policy and put that into evidence to solidify that annual reviews are required of their employees.
We disagree. We would have to call a witness. I mean, there's an email that we can move into evidence if they need it. It says specifically, and I can try to put up on the screen, from the director of HR hospital-wide, that for the review period of July 1 to December 31st, they were deferring evaluations. I think this is pretty clear.
Is this part of the deposition that you stopped?
No.
Well, didn't you move for a protective order during the
Not on this
deposition?
issue whatsoever.
Okay.
It was terminated when we tried to ask questions about the policies. So,
Judge, they're going to try to imply that we didn't do something that we couldn't do because of the changeover. That was fully covered in the deposition.
I'm sure you should make that decision.
Again, a central problem I've always had in this case is one side says the light's red, the other side says the light's green.
Well, we have the transcript, Judge, of the deposition.
sure. Let's put it up. Let's put up the termination of it.
What issue, I guess the defense would ask, what issue is are the plaintiffs trying to show that this specific policy would cover? And to what allegation?
Well,
I mean, did they want us to just stipulate? They have all of Kathy Beatty's policies.
there's a period of time that, of course, impacts the exact same period of time of Ms. Kowalski's hospital stay, that the hospital has an explanation for it, and the plaintiff is challenging the explanation. Whether the explanation is correct or not is not really, for me, it's a question of fact for the jury. So, at the end of the day, though, out of all the issues in the case, is this issue big enough for us to not rest today? And I really think we probably should be talking about the Joint Commission issue, because if the Joint Commission issue is going to keep the evidence open, that might inform what we're going to do on the policy issue. So that's why I kind of want to deal with the Joint Commission issue.
We would demand, request, the Joint Commission triennial survey that was just referenced, and the self-report that was referenced earlier, and any other associated Joint Commission or federal agency findings during that time, because both were referenced in Mr. Anderson's testimony, Mr. Witness Anderson's testimony. And we can set, I don't know if we need the deposition, but we need the documents.
And Judge, if they were left with the idea and the expert's testimony that this hospital was well run and they had been approved, there was a governmental and an industry approval process, and they passed with flying colors. Now, if that was not true, then this is a very serious matter. So we've had difficulty throughout this case getting documents from the defense, and we would really like to see all of those.
Well, look, if it turns out that this is only involving whatever the heart department is called, whatever you're calling it, that's not relevant to this case. If the incident or incidents that cause the finding of imminent jeopardy, and I'm assuming that imminent jeopardy means that loss of accreditation and loss of ability to receive federal funds, if that isn't the specific time period or soon after the specific time period of Ms. Kowalski's, it probably is not relevant. If, however, either of those two is true, that it is more systemic than just the heart department, and the time period overlaps or is very soon after Ms. Kowalski's stay, then the plaintiffs are going to be allowed to investigate and present this information to the jury. So I just, from a factual standpoint, that's why I need to rely on the lawyers, and I can't seem to get a definitive answer.
If we could get those reports, and we knew they were the right reports, this whole thing could be over. I don't understand why there isn't a phone call with an operation this big, and it's emailed over, and we print it out, and we look at it, and we go, fine. This is neonatal cardiologist. The judge says it's not relevant, not relevant. If it says what we think it says, though, it's a very serious matter. Because there was a duty to retract that representation if counsel knew that that was not true in the actual reports.
Judge, I have more information, but I don't have documents, and I'm not going to be able to wave a wand over this and get them now within an hour or so. May I respectfully suggest that we be given overnight to produce the documents that Mr. Anderson suggests that he wants? We believe that they will show that the triennial review that we did in fact have after this event was passed and did so handily. We also believe the documents will show that there was a self-report of the Heart Institute issues to CMS, JACO, and the state shortly before January of 2019, and that resulted in the IJ that was then lifted approximately a month and a half later. That is what we believe the documents will show. But I've got to get the documents, and I can't, unfortunately, I just can't do it on 10-minute breaks. And I, not that I don't appreciate being accorded them, it's just that it ain't that quick. So what I would suggest that we try to do, given the hour, I will try to get everything I can in the next hour, half hour, whatever I need to do. And if the documents aren't enough for the court and or counsel, then I'll do my darndest and I'll find out what we can do to produce someone who can explain and provide a timeline and try to put this whole thing in some kind of context so that we can move on and get this case done. That's what I would suggest.
Well, and I appreciate the not being able to wave the wand and get the documents. What I'm hearing, though, is we can't finish the evidence today. That's what I'm hearing.
If you'll give me some time to run out and work the phone, I may be able to do better. Here's what my problem is, Judge. I think I can get some of the documents that are at issue here within the next 15 to 30 minutes, maybe a little bit more, but in that ballpark. I despair, however, of the idea that those are going to satisfy counsel. Okay? I mean, we're not talking about, one page here, one page there. We're talking about some fairly beefy documents. So I don't want to tell the court that I can go out and wave a wand to get these things and then bring them back in and have, more backbiting about what they say or don't say. So what I'd like to do is try, and I'll do the best I can to produce everything I can as quickly as I can.
Well, I've got a jury waiting. It's 4:05. I've got directed verdict motions that have to be made, and if we're now postponing directed verdict motions to Monday, that impacts our jury instructions when everything is now waiting on these two issues. And so these two issues, here is what, if we can't resolve it today, this would be a proposal that I would give out. That the plaintiffs by tomorrow morning turn over the documents relative to, when I say this issue, the Joint Commission, CMS, the defendants. I apologize. That the Johns Hopkins All Children's Hospital by tomorrow morning turn over all documents relative to leading up to the imminent, what was the buzzwords, the imminent immediate jeopardy.
Got it.
That the All Children's Hospital, if requested by the plaintiffs, will sit for a deposition on Friday on that issue, as well as the policy issue relative to HR. And so that you can have sworn testimony on Friday. That way the parties can get a transcript and give it to whomever you need to give the transcript to, and that we walk in here on Monday morning and finish the evidence. Now, I would also suggest today that we do the DV motions, and we just all agree that we can do the DV motions, and if I have to change a ruling based on the small issue relative to the IG/policy, we can deal with that, but we still proceed with DV motions, and everyone agrees for time purposes we're going to do it right now. I've got Mr. Elliott on Zoom and Mr. Alton Burns here, and I am hoping that they don't have heartburn with this process. If they have heartburn about this process, this is a speak now or forever hold your peace type of moment. That way we can, if we have to take a little testimony on Monday, we will. If it turns out that this is a nothing burger, I think is what was said earlier, then the plaintiffs can just rest and we can proceed directly into closing, or actually jury instructions and then closings. So that would be my suggestion. Let me hear from both sides as to whether that plan of action is acceptable.
I think that's the best we can do with a bad situation, Judge.
Agreed. You just agreed.
Yes, agreed.
Agreed. The only thing I missed was, are we still meeting tomorrow before 10:30 to get you out of here by 10:30?
We are still meeting at 8:15 in the morning to go over jury instructions. We've got to get those knocked out. Now, I'm going to give the appellate lawyers, since I just asked the trial lawyers, I want to give the appellate lawyers an opportunity to weigh in on this time shifting of the directed verdict.
I don't see that as a problem.
Mr. Elliott.
Fine, Your Honor.
Plan, that's what we're doing.
Yes, Judge, I just want the record to be clear. The plaintiffs, other than this issue, are resting.
Well, I think we're going to call Ms. Kowalski for 2 nanoseconds for the homecoming pictures, and then we're sending the jury home.
Right, that's correct. I just want the plaintiffs to address that they don't have any other witnesses. They're resting other than this issue that was addressed by the court.
Plaintiffs, do you agree?
We agree. The fraud, billing fraud is we don't have to worry about the damages.
What?
And
I don't
we'll
know
have
what he's
that
saying there.
afterwards if they say yes to everything else.
He's not calling more witnesses.
All I want to know is, are there any more witnesses, Judge? I don't know about the billing fraud comment.
No.
So
Okay.
someone can let Dr. Corcoran know. Oh, I'm sorry, Mr. Altenberg.
On this billing fraud thing, they seem to think that they can have a jury instruction about having the jury figure out whether things are wrong on the insurance. Has that been resolved?
I think they want to bring in.
Can we do the jury?
Okay.
Post-trial thing.
Yes.
Okay.
So we can let Dr. Corcoran know he can go home for today and that he is on hot standby for a Monday morning testimony.
Hot standby.
Hot standby. First up,
Okay. 6 a.m.
I thought it was 2:30 a.m., Mr. Whitney. Okay, we're going to call the jury back in. We're going to put Maya Kowalski back on the stand. Again, this is just on the homecoming picture issue.
Yeah. Maya, please explain what went on with the homecoming picture a week or two.
And then,
and you can tell the jury to go or whatever.
well, I'll let Mr. Shapiro have an opportunity to ask questions. Then I'll ask the jury, and then I'll send them home for the day. And I'm going to tell them on Monday that the plan is to finish the case and to get jury instructions and closing arguments.
Yes, sir.
Excellent.
Please bring in the jury. Members of the jury want to confirm while you're away you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
And no one approached you about this case, is that correct?
Correct.
Did you see any media coverage about this case? Okay. Mr. Anderson, your next witness, please.
We're going to recall Maya Kowalski for just 2 questions. No, you're still under oath.
Ms. Kowalski, I just want to remind you that you are still under oath.
Yes.
Maya, correct me if I'm wrong, you were a little upset I did not leave you with the opportunity to explain those pictures from homecoming. Would
Yes.
you please explain to the jury what went on?
So there's 4 things I would like to touch on. So the first thing is that I got my dress the day before homecoming because I wasn't sure if I was going to be able to go. That was dependent on my physical condition and my mental condition. Secondly, I cried for an hour to my dad before that picture was taken because of how bad my leg pain was. I only ended up going was because my boyfriend is the one who paid for the ticket, and I felt too bad to say no. Third thing is that homecoming starts at around 8:30 for my high school. I went there about 9. I got dropped off, and I left before 10. I wasn't able to stay the entire time. Also, I did not post that picture, meaning the defense went as far as to look up my friend's account to get that picture.
Thank you.
Maya, I apologize that you feel that way. I did not go into your account. Those pictures were emailed to me by several people who wanted the defense to know about them. But while we're on the subject, you did go out for Halloween with your friends as well, did you not?
I did.
Where did you go?
I went to a friend's house.
Did you go out in public?
Sorry.
Were you out in public?
Yes.
Downtown Venice?
No.
How late were you out?
I think I went out at around, I want to say like 9, and I got back a couple hours later.
Around 11 p.m.?
Yeah.
Okay. Homecoming, when was homecoming?
It was, I think, about 2 weeks ago.
And when were you out for Halloween? Was that this past weekend?
Yes.
And there's been other times you've been able to get together with your friends during the trial as well, true?
True. But for limited amounts of time, and it's dependent on my condition.
One moment. Thank you for your time.
Mr. Anderson?
Nothing further, Your Honor.
Members of the jury, any questions? Okay, seeing none, Ms. Kowalski, you can go ahead and have a seat.
Thank you.
Can I see the transfer just a second, please? Okay, members of the jury, I had received a note probably about an hour or so ago about whether the jury would have various materials in front of it during its deliberation. And I would just again remind them that all the evidence that is relevant for this particular case will be provided to you in the jury room. All the admitted evidence will be available to you. Okay, members of the jury, let me tell you where we're at for your planning purposes. You know that you all will not be here tomorrow and Friday. I'm going to ask that you be back here on Monday morning, ready to go at the standard 9 a.m. My belief, what's going to happen is we're going to finish the rebuttal case, and then we're going to proceed into jury instructions and closing arguments. I do not know yet whether you will begin deliberations on Monday or if those will begin on Tuesday. But you can expect to be receiving this case, call it Tuesday, sometime on Tuesday at the latest. I want to remind you that you cannot discuss this case amongst yourselves. You cannot do any investigation. You cannot receive any information. Now, I also told you at the beginning of this case, and I'm going to remind you now, that we're going to take your cell phones during your deliberations. So when I say your cell phones, that would mean if you have an Apple Watch or some sort of smartwatch that's connected anywhere to an electronic device, we're going to take it from you. So, if the court deputies are going to guard those, but if you would rather not bring them in the courthouse, that's fine. You're not going to deliberate until I tell you that you can start to deliberate. So, we've gone this far throughout, and you keep answering the question that you have not discussed this case amongst yourselves. You cannot discuss this case until I say you may start. Okay, do we all understand that? Yes. Okay, we all understand that next week you're not going to have access to your cell phones or any sort of electronic devices when there is deliberations. You understand that? And I remember there was a requested, I think it was Wednesday. Was it Wednesday? Yeah, I think that was Wednesday. That we'll probably stop early on that date. We'll figure out the specific time. But other than that, when the jury is deliberating, you're pretty much going to be captaining the ship when it comes time to figuring out when you wanted to take breaks. Now, I'm not going to stay here until 1 a.m. in the morning like other judges have done with juries. I'm not going to do that. So we will let you go within reason to whatever you want to do, but no, it's not going to be 1 a.m. in the morning. But it probably will be past 5 o'clock that the juries, if you wish to keep deliberating into the evening, will do it into some reasonable hour in the into the evening. Any procedural question, nothing about the case, but any procedural question about next week and what is expected of you? Yes, sir.
Lunch off campus or provided?
When you begin to deliberate, the county will so helpfully provide you filet mignon. Pizza. Pizza. Or some sort of sustenance that is county funded. So, I know you once you begin, you're in. We're not going to break for lunch or dinner. The county will bring that in for you. Now, if you wish to bring, I know you have a fridge back there. If you wish to bring in your own food, I just don't have any cooking utensils to allow you to cook back there. But at least if you want to put something in the fridge, that's fine. Otherwise, we'll bring you something. And I promise you, it's not going to be filet mignon. It's not going to be some sort of gourmet fish dish or anything like that. I wouldn't say that. Any other questions? But I don't anticipate lunch on Monday. I think on lunch on Monday, you're going to be on your own. Lunch on Monday is not going to be during deliberation, so we will break for lunch on Monday. Yes, sir.
While we're back there deliberating, are we able to pass a note? Are counsel going to be out here if we have some sort of...
I will go over all of that in the logistics, but the reality is there will be an opportunity for the jury to send me notes. It's just when that happens, I then have to bring everybody and assemble everybody to answer them, and it usually takes a while because we're going to physically lock this room, and I'm not going to allow the parties to be in here. So they will be either outside, or more likely than not, they will probably be off campus. So it will probably take some time whenever there's a question. But yes, you will have that ability. Anything else? Have a wonderful weekend. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. We'll see you on Monday. Break, so everyone can shift, and if you want to leave, because we're going to do all the fun stuff like DV motions and jury instructions. But anything with like the trial lawyers present, do we need to? Oh, we need to talk about closing arguments. Yeah, why don't we take a break? Sorry, take a seat and let's deal with that. Let's talk about what the rules of the road will be for closing arguments. My recollection is 2 hours per side. Now, as far as demonstrative aids, I had a requirement in the opening statement that demonstrative aids would have to be shown to the other side, and I think it was 24 hours in advance or 36 hours. I don't recollect. So, one, do you want such a rule? And two, what time frame should we put on it for demonstrative aids? And demonstrative aids includes PowerPoint slide decks.
For me, yeah, I do think I want to use demonstrative aids. I think we're going to need that, and we're going to need to be able to use some summaries through that. I think as to any of the summaries, we should exchange those, and it needs to be far enough advanced so they can check it. In other words, with medical bills or, I don't know, ketamine infusions or whatever it is, we should have enough time to double check that the summary that's being put up on the board actually reflects what it is. So 24 hours should be good, I would think.
Yeah. So, and just, Mr. Anderson and I, despite all appearances, we actually work quite well together. I guess this is partly to Mr. Anderson, but demonstrative aids, if we're showing something that's not a piece, something in evidence, I would agree those should be exchanged 24 hours in advance. But if it's just your slide deck showing medical records, I don't need to see them, or photos that are in evidence, I don't need those.
We don't need to send each other's evidence, but
Right.
we've seen quite enough of that.
Right.
I just don't want there to be any sort of complaint come Monday, oh, they didn't show this to me or not. So
I'll put on the record exactly what I consider to be a demonstrative, not a demonstrative. I will have a PowerPoint that I will be closing with. If I plan to show, like I tried to earlier, sort of a Facebook page of these people are all children, that's a demonstrative, I will turn that over to Mr. Anderson. If it's just simply, here's the medical record from all children's, and I'm going to show them the history and physical, and CRPS came from an outside physician, I wouldn't think that Mr. Anderson needs to see that in advance, and I do not need to see in advance if he just is going to show an exhibit in evidence and that he's calling something out. To me, it would just be if there's a demonstrative, because that, in theory, could draw an objection. Do you see it the same way?
I see it the same way.
So what I'm hearing, let me see if I can articulate again. Anything that's admitted into evidence, you do not need to turn over. Your personal slide deck that you're going to base your argument on, you do not need to turn over. If there is a traditional demonstrative aid exclusive of the slide deck, that would have to be turned over, and let's just call it noon on Sunday. Is that an appropriate time?
It's fine with me.
I think so.
And I will err on the side of caution, Mr. Anderson, if it's something, because I don't want to draw an objection in the middle of my closing, and I think you feel the same.
As I decide on stuff, I'll shoot it over.
And I haven't forgotten Mr. Altenburn's request that he wants to check math. I haven't made a ruling on this. It's just Mr. Altenburn wanted to have some type of preview of the damage calculation that the plaintiffs seek. Now, that seems to be a one-way street, because I don't think the defense is going to be asking something similar, but I could be wrong.
If I can suggest, because I have no idea what it is other than listening to the testimony, I have a sense of the current methodology to do that. If he wants to share it with you first, and you tell him, decide whether I can do this on the fly and do the math, that's one thing.
I'm probably the wrong person, because if you're asking me, can you do the math on the fly? I do math on the fly all the time, so I'm the wrong person on that issue. So I'm just.
I'm not ignorant of math, but
I know that there was a specific request, so I'm addressing the specific request. So.
I don't mind turning up objective. Let's put it this way: the economic damages constituting bills and so forth. You still want to see that and double check bills. If I total up 12 bills, you want to see that?
No, I want to see the
non-economics, and you want to see it going forward and make sure that I'm using the tables that are in evidence and that I can count the number of days in the year, essentially. Hours in the day?
Hours in the day and categories been used.
Sure. But that's one of the things I said about summaries anyway, Judge. I thought that kind of...
Well, it's, he's going to want, I think, I don't want to put words in your mouth, but if you're going to go on a per diem type of argument, and let's say you're doing the number of good days at X number of dollars for a good day and Y number of dollars for a bad day, how many good days, how many bad days times how many years and all that, so that he can do the mathematical calculation to make sure we haven't rounded by a factor of 20 or $30 million. Am I generally correct?
That's right.
Except as the
I'm
amount.
expecting it to be per hour rather than per day.
I just work here, so.
Yes, although, the jury will be solving for X, which is the rate, whatever it ends up being by the day or hour.
So when is it fair for you to let the defense know your mathematical calculations of what you're going to be asking this jury for?
I don't think that it will take too long to check those. I'd like to have as long as I can. My initial impression would be noon Sunday, but I think I want a little more time on that because that's obviously a very important decision. We're coming in Monday for, are we putting it, well, it depends on the results of over the weekend, right?
Let me ask you this. At some point, I will be instructing the jury prior to closing arguments. So would it be fair if by the time that I start instructing the jury that the mathematical calculations be disclosed?
Yes, sir. That'd be fine.
Mr. Altenburn, does the calculator work that fast?
I'm sure someone's will.
Okay. Any other ground rules for closing arguments that we need to address?
I was almost not kidding when I said I feel like I should submit it to the court beforehand just to make sure we don't step over the line with one to the other, but I don't know that's fair to the court. I guess not.
Mr. Hunter.
Just an inquiry, Judge. Would the court mind, I believe Mr. Shapiro is probably going to do our closing argument. Do you mind if I handle the objections?
Yeah.
Well, I'll be doing that, and if Mr. Whitney can.
We'll let Mr. Whitney or Ms. Lawrence handle the objections.
Probably Mr. Lawrence.
Okay. Anything else about what we need the trial teams for before we take a break and then shift gears to directed verdict motions and jury instructions?
Just a question for Your Honor.
Yes.
A matter of timing. We intend to make a motion with reference to one of the jurors. When would you like to hear that?
Well, when's the motion going to be ready?
I can make it any time. It's going to overturn this motion.
I assumed it was going to come in writing. If you're going to seek to disqualify one or more jurors, I really would like that in writing. I'd like to have the ability to review whatever you submit with it and give the defense an opportunity. It might also require a discussion with a juror. So,
when would you like it, Judge?
file it by 5 o'clock on Thursday, that's tomorrow, and then a written response by 5 o'clock on Friday.
That's fine.
Well, can we say 4 o'clock?
Sure.
And when it gets filed, immediately send it to both my judicial assistant as well as the weekend email address. So both.
Yes, sir. Okay.
So 4 o'clock Thursday, 4 o'clock Friday.
I really can't believe we would be trying to invade the province of the jury at this point, but maybe they've got law.
I'm just setting up the process by which we'll have a discussion about it.
Yes, sir.
And that also means we're going to come in earlier on Monday.
Understood. Judge, exhibits. I'm happy to wait to deal with this Thursday morning. If the clerks are happy to do that. I know they had questions about one of the exhibits, so I don't know if they need that answer today about the audio in the joint. So,
What's the issue? What exhibit are we talking about?
okay,
What's the
so
issue?
there's several issues that we're going to deal with together about redactions and things, and we're going to get that together and give them to them in the morning. But they want, I think we want to confirm, correct, that on the joint exhibits, there was 1076 and 1077. I think it's clear that those were originally admitted. Those were the audios with Dr. Patrick, and then the court took that back. They were admitted, and then they were, whatever the word is.
Retracted.
Retracted, thank you. There is another audio, 1078. I think the clerks were unclear as to whether or not that.
Yes, at that time it was only the 1076 and the 1077, but not the 1078.
And we're happy.
Let's deal with one at a time because it's cleaner for the color record.
There's no dispute that 1076 and 1077 was retracted.
Does the plaintiffs agree that I hold those two out of evidence?
To remind the plaintiffs, those were the audios of Ms. Dr. Kirkpatrick.
I can't. Yes, I recall retracting 2 audio files. I'll trust that those are the correct ones.
Yeah, I think you can trust the court and county. And then the third one is 1078, which was put in evidence but never utilized, and it was just it's an audio of Beata and Kathy on November 3rd, the first phone call about the transfer to Nemours, where Beata tells her, I have to talk to my lawyer, and I'll call you back.
Is this for...
It's submitted at this point. So, I mean, we care if it goes back.
Which one, I'm sorry?
It's the November 3rd audio between Kathy and Beata about the Nemours transfer in November.
I don't care.
Either way, we don't care either way. It's admitted, the clerks, I think, had a good
Well,
question.
at that time, those three, I believe
We're
it
not-
was stated that they were not going to go back to the jury, but only 2 were retracted, not all 3 of them.
Right.
Well, if you want to take the third one out, that's fine. There's a medical record that basically says the same thing.
Yeah, we're happy to, it's a joint exhibit, so I don't have control over it. We're happy to just retract it.
We'd like to leave it in.
If I said we wanted it in, we should say you retract it.
Maybe, but that's what I wanted.
We don't care either way, Judge, we just want to clarify.
Well, it's in. Did I rule that it's coming out?
No, it wasn't discussed at all.
Well, if I rule that it's in, I'm assuming that there was consent for that recording.
That's the one where she told her she was recording. Okay.
And it's in.
Just to clarify, we were told not for all 3 of them
Not to go back to the jury.
Can someone play whatever exhibit we're talking about?
1078.
1078, please.
Can I help you?
Hi, my mom. This is Kathy Beatty with All Children's Hospital. I'm the social worker up here for Maya.
Okay. How can I help you, Kathy?
We have the excuse me, I'm sorry. We have the acceptance from the board, and we are getting ready to transfer her
We have a meeting today in regards to Maya's future plans. So we'll have a meeting today in regards to that at, I believe, at 3 or 3:30. And we're meeting with our attorneys today regarding that issue.
Okay.
So
are you giving us consent or are you declining consent?
I'm not doing either till I speak with the attorney and the coalition. We have 2 meetings today.
Okay. Well, but if you're not giving it in our viewpoint, that's declining.
Well, no, that's not what I'm saying. And just so you are aware, I am recording this phone call right now for your information. I am not declining. I am holding it off because we have a meeting today that was requested by the Children's Coalition. We have a meeting at 3:30. So we're going to attend this meeting first. And we also have a meeting with the attorneys. So till that takes place, then I can make the correct decision. Okay, Kathy?
Okay. So, will you call me back when you're done with those?
Absolutely.
Okay, I'm going to give you my number.
Okay, let me write it down. Hold on, please.
Yeah, stop it.
We don't want the number out.
Is the number in evidence?
No.
So we bleeped out the number?
No, I don't know that you did. We'd have to bleep it out.
Can we cut it from that point forward, Clay?
Well,
I'd have to go in and edit it out.
Yeah, we're gonna have to go in and edit it, obviously.
Okay, what is substantively, what else is on that call?
I think that's about the end of it. She says she has to call.
How much longer?
Call her back and.
Another minute?
Another minute.
Maybe we could listen to it in private between us and then decide what to do with it.
But that's it. That's pretty much it, Judge. She's going to call her back. She has to speak to her lawyers. It's at 3:00.
Well,
That's it.
it sounds to me like it's in evidence, and
we may need to cut a little bit.
I mean, I don't want someone's telephone number being in evidence, but other than that, unless there's another redaction issue, it's staying in.
That's fine.
That's fine, Judge. I just wanted to bring it to question.
What's the number?
10780. Okay. As far as I know, that's the only issue we needed your assistance on. The rest, we just need to make sure we have given them the correct redacted documents.
I have one issue on exhibits. 2060 is the mortality tables. We discussed this at one point. I believe it was only marked for identification. So we'd like to make sure that those are admitted.
I think that was because it's 60 pages long or something, and you were going to figure out which pages you wanted in.
What I would suggest on the plaintiff's exhibits is you go through your list, talk with the clerks either tonight or tomorrow, and if we've got to put any more plaintiffs in, we do it first thing on Monday.
Thank you.
Yeah, I'm not objecting. I'm just saying you need just those sheets that are.
Understood.
And there's one that council wanted to redact, and I don't know if you had a chance to look at that.
I have not, but Monday morning or tomorrow I'll answer.
Yeah, if you get that to me, then we can see if we agree. All right. I think that's it on exhibits, Judge, other than we need to just meet in the morning and make sure we're all good. Okay.
Anything else from the trial teams before we take a break to reset for DV motions and jury instructions?
Not from us.
No, not from the defense.
So for everyone's planning purposes, we will start tomorrow morning at 8:15, and we'll start at 8:15 on Monday morning as well. Okay, so let's take 5 minutes, and we'll reset for DV motions and jury instructions. taken care of, let's first go to directed verdict motions. It would seem to me that we first need to address any motions that the plaintiff is going to file for purposes of, assuming that the defense had rested their case. So, Mr. Elliott, why don't we have you unmute yourself, sir?
Yes, and Your Honor, I will defer to Mr. Anderson because I'm not aware of any that we want to make. My understanding is the Fab Ray thing dropped out, and I'm not sure what other defenses there are, so I'll defer to Mr. Anderson.
Judge, just for the record, the plaintiffs move for a directed verdict on all counts, all defenses, and in particular the medical malpractice, because there is insufficient evidence, actually no evidence in the form of a reasonable degree of medical probability as to the psychosocial allegations against or proposed diagnosis against Maya Kowalski. Through the course of this, the defense has not presented a single expert in the area of psychology who can testify to a reasonable degree of medical probability that this is something other than CRPS. And so we move for a directed verdict on the medical malpractice count in particular, and if not, then a determination under the DV that the issue of the diagnosis has been decided.
Okay, so just so I'm clear, because let me tell you my interpretation of your motion. That right this second, you are only moving for a directed verdict with respect to the claim of medical negligence and not every single count. So, does the defense wish to respond, knowing that I know that there was some testimony that Maya Kowalski doesn't even have CRPS?
If you need a response, I'll make it, but I don't think I should need one.
I just want you to say whatever you need to say, but this motion is going to be denied, so.
Then there's nothing I need to say.
The court's going to deny the first motion that the plaintiffs moved for directed verdict as to the medical negligence. And Mr. Anderson, any other motions for directed verdict that you wish to make?
Well, I made as to all claims of all counts in defense as one for the record, Judge. I'm not arguing any of them.
Well, I don't want to. Oh, okay. Mr. Altenberg.
And because of the current status of the rules, I don't actually have to renew a motion for a directed verdict at the end of all the evidence like I used to, but my stomach tells me I'm supposed to do that.
Well, I'm saying to respond to Mr.
To that? No, I won't respond to that argument.
I'm going to deny the motion.
I'm so hurt.
Well, to be fair, I'm not sure that motion did anything to preserve anything. So if there's something specific you want me to focus on, now's your opportunity.
No, Judge, not at this point.
Okay, so
no.
So at this point, there are no further motions being made by the plaintiff for purposes of directed verdict. Is that correct?
That's correct, Your Honor.
Let me shift over to the defendants. We are assuming, as we discussed earlier today, we were going to do DV motions now, even though technically we have not closed the rebuttal case. Mr. Altenburn, whatever you want to do now the floor is yours.
All right. As I said, by the rule, I don't have to renew anymore, even though I'm by instinct used to doing that. So I'm going to try to limit this as a result just to 2 or 3 things. First, on the claim of fraudulent billing. My argument was before, and that, first of all, that they had put in no representations, let alone misrepresentations of evidence in their case. And that was because they were relying on only documents that were a database from Aetna Insurance Company and nothing that had ever been sent by or received by the Kowalskis or Aetna from Johns Hopkins All Children's Hospital. Now, today they tried to put in and did put in some bills, but that doesn't cure the fact from before that they did not have that when I made a directed verdict at the end of the case. Those, if there's a representation, it's going to be in those documents, and they were not in at the end of the plaintiff's case. Moreover, those documents are not self-proving. And what the misrepresentation has to be material to something that Aetna did. The evidence we put on confirms that other than $11, there was nothing questioned by Aetna. And as a result of all of that, that there was something that they did or did not do relying to their detriment on that, either by their insurance company or them. The proof on that is just not in. This is, if it goes to the jury, it's total speculation about all of this. And yes, there is a lien to be resolved by you at the end of this, but I don't know what they're supposed to decide as a jury question about the lien based upon the evidence that's been put in. So I continue to believe that there should be a directed verdict on the fraudulent billing count.
Plaintiffs.
There was evidence, actually, I don't believe we needed it because we passed directed verdict, but their expert actually connected up even more the relationship between the Aetna billing for CRPS and their representations in the medical records and their submissions. There was testimony in the record from Brewerton and from Chopra as to the different types of treatment that the Kowalskis would need and have to pay for. There was also, and I think we're going to get into the damages aspect of this. Oh gosh. Testimony from Brewerton and from Chopra as the future. I'm just trying to think. There was one other one, Judge, where, oh, I know. We had compared the amount of psychosocial, CBT that they're supposed to have with the amount they actually received at Johns Hopkins. And there was a huge disparity between the two, indicating that Maya, all regional references in our favor, Maya did not receive everything that she was supposed to receive if, and the testimony was, that the diagnosis would be enacted on CRPS.
Any very brief response?
Very brief response on this, Your Honor, is that the evidence on this as to CRPS being on the document, there's no dispute that she was 100 days in the hospital and that she got room and board that was billed for it. There's no dispute that they're not claiming that she didn't get physical therapy or occupational therapy or cognitive therapy. They're claiming that she should have had more than she did. But they're not claiming that we billed for things we didn't do for those. And the evidence, even from their own experts, is that that's what you should do first before you go to their theory of ketamine treatment. And there's no evidence ketamine treatment can be provided by any hospital in America for this. So there's just no evidence of fraudulent billing.
Okay, the court's going to deny the DV motion on fraudulent billing.
Okay.
Next one, Mr. Altenberg.
The next one, I continue to believe that on negligent infliction of emotional distress, that they haven't alleged nor have they proven a tort of negligence that occurred to either Bieda or Jack Kowalski that can be on the verdict form, and that without proof of the predicate offense, or the predicate tort rather, there's no claim for negligent infliction of emotional distress, even if the evidence they put on was sufficient enough to manage to squeak over the line on physical injury.
Before we continue on this motion, I forgot to ask the plaintiffs where you are on the negligent training. Are you?
We're sticking with it for right now, Judge. We'll decide over the course of the weekend if we need it. But I'll tell you our concerns. Our concerns are we never know where the defense is going to go once we make a move. And it's not that we don't trust them. We just don't trust them. And so whenever we're making a decision like this, I have to look down the road to the potential ramifications. What I'm concerned about is I don't want to draw some defense that we didn't show underlying negligence or more from the hospital itself in combination with Beatty under 768.72 through 0.76. So that's one of and the primary reason I still got it in here, that's something we can talk about depending on what the defense wants to do.
Okay, well,
Your Honor, if I could add in,
Sure.
one of the things you'll see in the instructions, or maybe it's in the verdict form, I think it's in the instructions, is that, if the defense is willing to agree that negligent training can be discussed as part, in the closing and so forth, as part of the other claims, then we wouldn't need a separate interrogatory verdict on it. Because to your point the other day, it would be overlapping damages, but we're going to take care of that with a non-duplication instruction. But still, we could simplify it if they're going to say, I think Mr. Anderson's concern is we dismiss that, and then as soon as he mentions negligent training and refers to the evidence on it, they say, well, that's not part of the case.
Exactly.
Although it was incorporated by reference into the medical malpractice claim, it still would have to be something that a doctor or a nurse did that breached the standard of care that caused physical injury to a child. And so, I've heard an awful lot about a lot of things other than doctors or nurses causing a physical injury to this child that results in bodily injury and then all the things that flow from that. And so, I don't see that any of the training thing by itself, when there's no allegation of anybody being outside the course and scope of their employment. The whole theory is that these were trained doctors or trained nurses and they fell below their standard of care, causing a traditional medical malpractice claim. And so I don't think that this negligent training stuff is appropriate part of the argument, but I'm not going to give that up just because there's a count there that from the very beginning has been the smorgasbord. They've been using this thing to create this big ball of spaghetti that you can't tear apart. So to have a simple story ends up being this in the jury instructions, and I forget how many pages now, 14 pages of a verdict. And that's going to be very, very difficult, and it's because of count 14 to a large extent.
I sidetracked us, and I apologize. Yeah. Mr. Altenburn just moved for a directed verdict on the count 6C, the negligent infliction of emotional distress.
That's correct, Your Honor.
So,
Your Honor, I can speak to that.
Yes, please. Now, Mr. Elliott, you need to give your best shot, because this is the one that, in my mind, has been kind of on a tender read.
Yeah, Your Honor, if you look at the Eighth Amendment complaint, at paragraph 119, it pleads that Maya witnessed negligent acts toward her parents. The argument, there doesn't have to be an underlying claim for negligence by the person who is the victim of the underlying acts. If I'm understanding the argument and what's being said in the draft instructions you're going to look at, they're saying, well, there's no evidence that Beata and Mr. Kowalski made a claim and that for this, and they don't need to, because when Maya witnesses the negligent acts toward the parents, and they may be maybe some negligent, some intentional. The jury will sort that out. But when she witnesses the negligent acts, that's enough. That is the negligent infliction on her, seeing the way her parents are treated, and they don't have to have filed a separate cause of action for that. That's just not part of the requirement, as I see it, not in the instructions and the law.
And if I may add, there's plenty of evidence in there that after a certain amount of the abuse by Beatty and in those conversations, so Maya just kind of gave up. It's even in the nursing records that she had given up and was losing strength and becoming less able to do everything. And so that is an injury.
Mr. Altenburn.
I know Your Honor's not fond of the impact rule, but the problem here is that there's no case that says what Mr. Ellicott says, that you can have negligence in the air and proceed with this. And what you have to have is you have to have a breach of duty that caused a physical injury and impact to somebody that they witnessed, and that has to be an actionable tort. I know of no case that says anything other than that, so I think I'm entitled to a directed verdict.
What I'm going to do is I'm going to take this under advisement. I'll give you my final ruling tomorrow when we're discussing the jury instructions, but I want to think about this one a little bit overnight.
And the only other one that I'm going to argue is count 14, and it's this. The argument I've made before is that we're now at the close of all the evidence, and the jury instruction is that it's supposed to be a negligent standard by the hospital training doctors and nurses, and I guess it's slipped in staff right now. I'm not sure what staff, but that has to, by itself, without the actions of another human being, result in damage to people. I heard the expert say that it was his expert, I guess, legal opinion that violations of these standards caused injuries to somebody, but there's got to be a whole bunch of things in between, and that's what's left in this lawsuit, especially in the medical malpractice claim and in all these other claims. So this thing has never stated a coherent cause of action from the very first time it was pled, and it still does not, and they haven't proved whatever it is. So
the November 12th notice of Kathy Beatty not only trying to pick a fight outside with a coworker, but having had it 2 times before. Then, following that, no training or retraining whatsoever. That is more than enough evidence in the record to show that had she received the training, or let's say a reasonable inference, and as pled and as proven, that had she had that training, or any steps had been taken, she would have not have been there to continue to harass and commit intentional acts on Maya.
And that was count 11, that she would not have been there because of retention, and they dismissed that in exchange for my promise that everybody was inside the scope and course of employment. This is just trying to try 11 in 14, and that's not a negligent training. So we're supposed to have trained her after November to prevent things in what time period? There's no proof.
Wasn't that just all what Corcoran said?
Well, I will let you know in the morning when we deal with jury instructions. I'll take this one under advisement. Is there anything else specifically you want to do, Mr.?
No, Your Honor.
Your Honor, on the, and I know we're going to cover in jury instructions, but the reason staff is there is, staff is pled. If you look back at the underlying allegations of 14C and what it incorporates, it does refer to staff. And was my understanding that there was some contention by the defense that Beatty was not a healthcare provider, part of the healthcare providing team, but just staff. So that's why staff was put in somewhat late in the day.
Now, I think at some point Mr. Altenberg said he wanted, and maybe it was Mr. Elegant, wanted to do jury instructions starting tomorrow morning. Was that someone's request?
It was my observation that I thought we'd probably be at 5:10 before we got to this, and that the truth is that you
5:12.
that you probably want to stare at these things a little bit, and that it's probably faster. I'm willing to come at 8:05 if you want me to. I'll be here whenever you want me to be here, but I have a feeling this will go faster if we start tomorrow morning than right now. So,
Mr. Elliott, are you okay with that game plan?
Well, I'll do whatever you want, Your Honor. I'll stay as late as you want tonight or come as early as you want tomorrow.
Assuming that I make timely decisions, which I promise to do, are we going to be able to get through these jury instructions in the verdict form in 2 hours?
I will do my very best to do that. The only thing that's really hard is the suicide one, and I do need to kind of preserve that and try to get hopefully the best instruction I can on that. And I will tell you that I've written something that's all on irresistible impulse. I've gone through a litany of things that you don't want to give. You've been interested in that, so I've written as my last approach to this something that I think is along the lines of Nelson and uses the Nelson language, which they suggested early on. The problem with your alternate theory of substantial cause, and I put that in a long memo, and you were in trial, so I'm sure you haven't seen it, is that it confuses causation of damages and causation of a tort, because this is a situation where we have to have conduct that, for a normal one, we commit this conduct with the intent of causing emotional distress that causes people damages because they're emotionally distressed. It's not that you can go on and say, okay, now that there's emotional distress, was it a substantial cause of a damage called death? Because the death was caused because someone killed themselves. So they would normally be the intervening proximate cause. This is a little bit like in a situation where they're charged with hurting someone else, and the only way they get off is by showing that they were essentially insane at the time. And so if you go to irresistible impulse, it's that the conduct has to cause not just the standard level of emotional distress. The conduct has to be severe enough that it causes not just the state of mind of emotional distress, but the state of mind of irresistible impulse. So stated again, it's not that you have a state of mind initially that's one thing, and that somehow transitions into your mind into a greater state of mind. And that is frankly what the courts who use that phrase in other states haven't thought through because they hadn't gone to trial. It didn't sink into me until I was a little while in trial as well.
Well, are the plaintiffs riding on both theories or just one?
Your Honor, we would like both. Not really theories, I guess, as much as alternative causation, if we're going to use that terminology. And I have proposed in the somewhere in the instructions, or maybe it's in the verdict form, I think it was the instructions, that the way to do this, in keeping with the court's expressed desire that I think we all share, not to have to repeat anything we don't have to, is instruct the jury that they will be asked to consider A and B, and then put A and B on the verdict form. Put substantial cause, put irresistible impulse on the verdict form, and let them answer yes or no to each of them. That way it will be fully answered, and if the appellate court thinks it's got to be one and not the other, they'll have the answers to both.
That generally is where I am with the wrongful death instruction, that I recognize that there is scant case law out there, and
but
I picked the wrong horse, so to speak, and I don't put both variants on there, then the appellate court's not going to have the ability to know what the jury actually found. They could check yes to both. They could check no to both. They could check yes to one, yes or no to the other. So it to me is the safer course under the unique circumstances that we find ourselves in with this cause of action, to have and instruct the jury on both.
So a couple things. First, as we've discussed before, having alternate complete causes of action that you do in this fashion, and having to select one or the other at the end, see whether one's correct or not. I understand that, but to have a single cause of action where we're going to give them one instruction on causation based on conduct doing one thing, and another instruction on whether the emotional stress that was caused by this, what in turn was a substantial factor in a suicide. They're different theories. You're going to have to explain to the jury in some way that this one theory is a whole lot harder to prove than the other theory, because they're going to see these as parallel kinds of things. I don't see how we can possibly do this without further confusing a jury, and the ball of spaghetti will win on this. This case has to be sorted out, and he wants this kind of thing to throw the whole thing at them in an emotional fashion where they cannot go through this and resolve it rationally. So no, I don't agree with that.
I understand you don't agree, but we're going to do it. So I intend on allowing both to be instructed on, and an interrogatory question or questions on the verdict form.
Tomorrow will take a little longer because I want to argue then a little bit more about what the definition of substantial cause is.
I know, but because this is an issue that I know is going to take time, I thought it best to lay my cards on the table. That's where I'm going with it. So we need to operate within those parameters. And I fully recognize that the defense vehemently objects to the proposal to put both on the instructions in verdict form. So I I fully acknowledge that, but I'm overruling the defense and we're going to do it.
Okay.
Your Honor, would it be helpful for you to have, if Mr. Altenberg and I can work a little bit longer on it tonight, to have something over to you that reflects that?
And I know you sent something, and I've got it here. You sent something at 2-something this afternoon. I haven't been able to synthesize it and how it's different than last night's.
That is the latest that we've worked up together, and we actually work well on this, I think, Your Honor. We commented to ourselves earlier in the day on that, but we obviously have some disagreements. But I think we're working well toward the end and trying to incorporate the rulings. That one's farther along than last night. With this, and when we know what your rulings are in the morning, we'll be even further along. But I think there'll still be a number of things for you to look at either way.
Well, to answer your specific question, if there is specific language that furthers the effort, I am all for that option. If you don't want to work on that tonight, if you don't think it's going to be fruitful or productive, then let's not. And let me just hit one other low-hanging fruit on the definition of manager.
Yes.
I want to go with the second DCA language out of, was it the Dominguez case?
Dominguez, yes.
Yeah, that I'm going to go with the second DCA's language.
Okay. And if Mr. Elliott wants to, it'll be a while till I get back to a hotel room. If he wants to work on something more on the second factor, I don't know whether you're trying to get definitions of that in there or what you're going to do, but if you send it to me, I'll look at it when I get there.
8:15, and let's try to, hustle as much as we possibly can, and I will hopefully announce the first thing what I'm doing relative to those 2 DV motions I took under advisement.
Very good, Your Honor. Thank
Okay.
you.
Thank you, Your Honor.
We'll be in recess. See you all 8:15 tomorrow morning.
Thank you.
Mr. Cottrell, since you stayed today, can you let Mr.